and this honorable court.
Be seated, please. Welcome, everyone. On behalf of myself, Scott Brister, Scott Field, April Ferris, it's a pleasure to see such a crowd. First of all, we want to thank the University of Texas and Dean Chesney and his staff. They've been tremendous help and accommodation to a court that has no courtroom. We're working on that. Matter of fact, we met with some of the people in the governor's office this morning, but it's not going to happen anytime soon. Courtrooms just don't appear in downtown Austin very often, but so we are working on that. We've got 4 cases set on the docket this afternoon, and so we will be strictly enforcing the time limits so we don't get out of here. So we'll get out of here just in time for rush hour. So the first case, called Stephanie Muth in her official capacity as Commissioner of the Health and Human Services Commission versus Cook's Children's Health Plan. Who's present for appellant?
Corey Scanlon for appellant, Your Honor.
And you will be splitting time?
Yes, Your Honor.
Okay. So you all are responsible for splitting time. So if he takes too much of your time, that's on him, not me, okay? Thank you. And appellees?
Your Honor, Warren Huang for the appellees, and with me are my colleagues, Benjamin Grossman and Kerry Wong.
Thank you. Mr. Scanlon, you may proceed.
Thank you, Mr. Chief Justice, and may it please the court. The Executive Commissioner of the Texas Health and Human Services Commission is statutorily delegated authority to procure contracts that provide best value to the agency in the areas of Medicaid and CHIP managed care. The trial court, at the urging of disappointed bidders whose incumbent contracts were set to expire, improperly enjoined the most recent iteration of that procurement, which caused the entire statewide procurement to halt, which allowed losing bidders to hijack federal Medicaid and CHIP dollars, and which caused uncertainty for millions of low-income Texans in their health care. That was error, because the disappointed bidders sued before allowing the statutory protest process to conclude, but more fundamentally, because every one of the disappointed bidders' claims is barred by sovereign immunity.
When should the suit have occurred if it was going to occur?
And I'm assuming that we're talking about an ultra-virus suit.
Yes.
In the contact procurement arena, there could be an opportunity for a suit for mandamus at the point that the request for proposals, which outlines how the procurement would go, is protested, and if it is clear that the commissioner is going to proceed with an illegal act, that would be the time to file a suit for mandamus. These bidders did not do that. They rolled the dice and decided, well.
So let me make sure I got that. Request for proposal is issued. I mean, they issue request for proposal, have a chance to or maybe comment before the RFP issues, then after the RFP issues, you have so much time, and you've got to file in that usually 30 or 60-day window.
So it's a little bit unclear. A mandamus action would only accrue if there was no adequate appellate remedy at that point. So if we're going to proceed with a procurement, the RFP demonstrates it's fundamentally flawed in some illegal way. Once they agree to move forward with it anyway, there's no mandamus action or ultra-virus action at that point. They would have to protest the appeal, and that's it. And I understand that that could be maybe counterintuitive to the court, that there wouldn't be an avenue for judicial review. But that is the balance that the legislature has struck with the Medicaid program. That's what you see in other procurements where immunity has been waived. County or municipal procurements have a specific statutory provision that say it can be enjoined. You don't have that here. So the legislature has not intended for there to be any judicial review. With the ultravirus case, it becomes retrospective also at the point that the RFP has been locked in and the bidders proceed with the procurement. So that's the opportunity to assert the illegality in the process.
So I like the idea of mandamus. The great thing about mandamus is you don't have to grant it all the time. You say, well, this is important, this one's not, this one's a close call, this one's a clear abuse of discretion. Ultravirus, every case we get these days is an ultravirus claim. If you don't have any ground, you just allege ultravirus, and up you go to the 15th Court of Appeals. But now, may need to cabin this in a bit. Why would you not have an adequate remedy if the RFP bids aren't in? And could you tell from the RFP, I'm going to lose this bid, so I have suffered an injury?
That's the problem with the ultravirus claim in this case. Ultravirus claim, you have to establish that the state official exceeded or they acted without authority. That claim, we've argued, is not right at this point because you still had the protest remedy. You had the protest appeal, which, again, there's two protests I want to make sure I'm clear about. You can protest the RFP. You can protest the notice of intent to award once the decision's been made who's going to get the award. And then there's an appeal to the commissioner. That appeal, the testimony is clear. It remains pending. Commissioner Young testified, I'm not going to sign the contracts until I'm able to decide the appeal. And I can't decide the appeal because I'm enjoined from taking any further action in the procurement now. So that was the fundamental problem with the ultravirus claim here.
But isn't it true that, okay, let's just play that out. The decision's made by the commissioner, and at that point, if there's a claim made that the commissioner didn't follow the statute in this procurement, the defense by the commissioner is going to be, well, that's retrospective relief. We can't do that anymore because this is already done. Whereas the only chance you have for ultravirus is you got to stop something from happening in the future. I mean, isn't that just as a practical matter what they were faced with here? Because you have to do something now or you lose it. That's
correct, Justice Field. And I want to kind of go back to what the question about ultravirus was, I think, in Hall v. McRaven. They said that we cannot allow the ultravirus exception to swallow sovereign immunity. And one of the fundamental fallacies that the other side has been arguing is that there's general jurisdiction to enjoin ultravirus acts, and that is not how sovereign immunity works. The presumption here is that the state is immune from suit, and ultravirus allows a very narrow remedy. And the case law in the procurement context has said it's retrospective if the contract has already been awarded. I'd cite the Utility Associates case for that, where they said it's not about when the contract gets signed that makes it retrospective. It's also asking to undo the decision by the city council to award the contract. And you have that here. That's very analogous to the agency making the decision of who is going to receive the award.
What do we do with the Wilson versus Community Health Choice case?
So the procurement was consistent with Wilson. That was a big issue on how mandatory contracts were going to be awarded under 533-004. Wilson said that the commission is not permitted to simply invoke a best value judgment to undo the provision in 533-004, which says you shall contract with a MCO that meets these certain criteria. None of these bidders meets those requirements, and they haven't asserted a 533-004 claim either. So this was consistent with Wilson. Wilson also says there was a possibility of prospective relief there because there was only one bidder that met the criteria, and you had a situation where the procurement had actually been canceled. So there was going to be another procurement. This procurement, by contrast, has been halted. It's been enjoined. And
did the previous contracts lapse? Was there a drop dead date on them, the expiration date?
I'm very glad you asked that, Mr. Chief Justice. These contracts are all set to expire, and this goes to their injury. And I want to talk a little bit about our standing.
Set to expire when?
They were going to expire before the new contracts were going to go into place. I don't know the exact date, but would
you let us know the exact date? Because it's, I mean, This is not the first area of the law where if you can get a temporary injunction, you can keep something going forever.
The contracts have already expired. So
Okay.
right now, they're getting these extension
We
contracts.
just have to extend it because we have no choice.
Yes, and that's another problem I can talk about. But if I may, I would go back to the standing argument. They've acknowledged that they're not asking for, they've claimed they're not asking for retrospective relief. They say that all the relief we're asking for is to halt the procurement. That's it. And the problem with that is the irreparable injury they've asserted, the possibility of business dissolution, the loss of their employees to poaching, which I fail to see how that's traceable to Commissioner. But anyway, we cited the Myers case that says if the injunctive relief is not going to redress the alleged injury, there's actually no standing. So they lack ripeness, they lack standing, and this is a retrospective form of relief. Turning to the TI itself.
Well, before you get there, I'm going to talk about ultravirus a little more because, frankly, the case law in this area is just a mess. And Houston Belt talks about statutes that provide absolute discretion. Are you claiming that this statutory scheme provided the commissioner absolute discretion?
It does provide absolute discretion to determine best value. So the statutory requirements that we are arguing about here today are all discussed in the request for proposal. There are two mentions to each of the statutory provisions, and the best value judgment is the main consideration. The provision says that the commissioner shall acquire goods or services by any procurement method approved by HHSC that provides the best value to the agency. Because of what happened in Wilson, where they said you can't just use best value to argue anything. Well, the agency took a very, very close look at that, and they said, here's what we're going to do. In this RFP, we're going to develop best value criteria that are going to explain how the commissioner is determining best value. And it developed 18 technical questions that fall under those best value criteria. That was the manner in which the commissioner exercised her absolute discretion to determine how to weigh these statutory factors. It was explained very well in the RFP to all of these bidders. So with that in mind, I want to kind of talk about the temporary injunction a little bit, and I want to flag tab 2 of the appellant's brief. That's where we've kind of put all the statutory language because this code has been redone non-substantively. So all the text is there to help with that. There are 13 bullet points in the TI. I don't have the time to go through all of them, but I'm happy to answer questions. But I want to talk about 2 of the main ones. One of the, I think, most egregious one was that the TI incorrectly stated that past performance was required to be considered. The statute says that the past performance may be considered. The exact language is that it may consider indicators of probable vendor performance under the contract, such as past vendor performance, the vendor's financial resources and ability to perform, the vendor's experience and responsibility, and the vendor's ability to provide reliable maintenance agreements. Again, may consider. And that's 1 of 11, and past performance is only a subset of that long list that I just read off. So the notion that they were required to consider past performance is just fundamentally wrong on the face of that temporary injunction order.
But getting back to the absolute discretion for a moment, do you agree, though, that there are some of those laundry list things that it was a shall? You shall do X, you shall do Y, you shall do Z. So how do we balance? Are you claiming that the statute that provides the absolute discretion is in conflict with that list? Or how do these go together?
I would assert that the way that it was harmonized in this case was that for instance, the preference, the shall give preference statutes. Now, a preference doesn't dictate the outcome. Ask any veteran who's applied for a federal job that they didn't get. The preferences say that can be, something that's weighed among all of these factors in the statutes. And they did that in the best value criteria. I can give an example on the quality initiatives point. Technical questions said that describe the respondent's quality improvement and performance valuation strategies. So that was it was solicited from these bidders. It was incumbent upon them to describe in their response how they would win that preference. So all of the best value criteria, I think we exhausted the discussion of that in our brief about how that was implemented into the RFP. And then if you look at Mr. LaFawn's bench exhibits 4 and 5, that's going to show you the scores. How did they score those best value criteria? Everything was documented in accordance with the statute. There is absolutely no way to argue with a straight face that the commissioner went outside of her statutory authority to procure these contracts. Very quickly, actually, I see I'm almost out of time. I'll go ahead and let my friend come up.
Very wise. Thank you, Mr. Scanlon.
I had the same reaction and was about to ask a question and realized now it's just going to be Mr. LaFawn's now.
Well, you should feel free to ask it, Justice Field, of course. May it please the court, Jason LaFawn for Molina Healthcare of Texas. HHSC, on behalf of the state and acting in its proprietary capacity, desires to acquire services via contract from managed care organizations like Molina Healthcare of Texas. For 2 years and counting, appellees have been interfering with HHSC's effort in order to protect their incumbency as service providers under long expired contracts. Their justification is that HHSC is allegedly failing to follow instructions given by the legislature in how to choose whom to contract with. But it is the appellees who are ignoring the legislature's instruction and asking the courts to as well. The legislature has directed where procurement complaints are to be heard. They are to be heard in the agency protest process. There, as the legislature intended, complaints about violations of procurement statutes and regulations are determined by the agency, and if they're found, what the appropriate remedy is.
But don't we have a kind of a weird scenario here? Under 391.309, says a contract won't be awarded that is subject to a properly filed protest until HHSC files a written disposition. But the HHSC executive commissioner may waive this requirement if the commissioner determines that HHSC must award a contract without delay to protect the best interests of the state. Is there another provision like this?
Yes, Your Honor. In fact,
Okay.
that's required by law. So what the statute says, 2155.076A, is that the agency's rules have to match now the comptroller. When it was, back in 1997, it was the General Services and Purchasing Commission. And that type of rule has been in place at least since 1987, and it existed in 1997 when the legislature told agencies to follow those rules. But what is left out of the bench exhibit of the appellees is the provision that protests may be heard after awards, and that unlike an ultra vires claim, a protest may void a contract. The result of the protest is that you may void a contract. The protest process gives the appellees a far greater range of remedies than their ultra vires claim does. But what it doesn't get them is delay, which is what they have always wanted. Because we talked about the expiration of contracts. Every year, there's a bridge contract because there's no other way to do it. And so every year, HHSC is extorted into operating with partners in the state's largest program that it does not want.
So let's play that out, though. Let's say you decided to do the protest, go to the commissioner says no, then what?
Then, Your Honor, much like in Houston Belt, the plaintiff there exhausted remedies and then sued on an ultra vires claim. It does not mean that their ultra vires claim is going to be successful, and in fact, it may not be. And if that's true, then protesters, those desiring to contract with the government, have the same remedies as those who have contracted with the government. They have an administrative process, and failing that, they may petition the legislature for permission to sue. there's no problem with that because these are all legislatively created processes. There are no inherent rights here involved.
But as a practical matter, I mean, for anybody who's ever had to file a lawsuit against the government, you're then retrospective reliefs, you've got no ultra-virus, you've got sovereign immunity. I mean, isn't it? It's basically a dead letter at that point, isn't it?
That's correct, Your Honor. Just like anyone who contracts with the state, although this is because of the nature of this process. In Houston Belt, they were able to sue because there was ongoing enforcement. That is the usual case. Most ultra-virus claims will have that, or they'll have some violation of right, which we're also missing here. And when the legislature created the protest process, it knew and intended that the agency was going to be the ones looking at the procurement statutes and the procurement regulations and deciding whether or not they were violated, and if they were, what the consequence was. The appellees are asking the courts to do
Isn't this statute
that.
different, though, in terms of, I mean, we've seen, and I know you have in your old job, plenty of statutes that give exclusive jurisdiction and administrative remedy, and that's it. This doesn't look like those statutes. You need to
Well,
comment on that.
So I would ask Your Honor to consider the statutory history of the protest statute. It directed the agency to follow the rules of the Purchasing Commission. For a decade prior to that, the Purchasing Commission's rules said it is the Purchasing Commission that protests will only be about statutory and regulatory violations, that it's the director of the Purchasing Commission that looks and decides whether or not there is a violation and what the appropriate remedy is. If Your Honors look at the Regent Rule in Houston Belt, not Houston Belt, in Hall v. McRaven, we have an identical situation. The legislature intended that the agencies would be the ones interpreting these rules because these are instructions from the legislature to an agency, and as Inri Stetson explained, sometimes they are just that. They are instructions, and that's how the two communicate with each other. And there are many mechanisms within the executive branch and the legislative branch to address compliance with these rules. You can go back a few years, and people at HHSC lost their jobs because of things that happened during a procurement. There is real enforcement here. The legislature cares about it. The legislature had a hearing on this procurement right after it in the middle of the protest process. This is not something that slips under the radar. It has, the way HHSC has done it, it is proceeding exactly as it is supposed to. The appellees and the district court have never presented any cogent reason why HHSC lacks authority to at least finish the protest process, because there is none. They clearly have that authority, and if the appellees are out of luck after that with a claim, their complaint is with the legislature, not with HHSC.
Are you familiar with any cases that have said that you can't file an ultra-virus claim in court if an administrative proceeding is ongoing?
Yes, Your Honor. Aspire Ventures from this court last month said you may not file an ultra-virus claim when an agency has exclusive jurisdiction.
I was saying, there's the key. I was waiting on it. Exclusive jurisdiction we'd have to find, correct?
Yes, and there is a pervasive regulatory scheme here, just like in Janet, and this is clearly within the scope. Thank you.
Thank you. Ms. Wong?
Good afternoon, Mr. Chief Justice. May it please the court. This appeal is about the Commissioner's unlawful attempt to obtain absolute and unreviewable authority to award up to $120 billion in Medicaid and CHIP contracts that will affect millions of Texas's most vulnerable women and children.
But you're not representing the vulnerable women and children. You're representing a big healthcare company, right?
Your Honor, our health plan includes over 500,000 of those women and children, so we are.
Of course it does, but you were not hired by those 500,000 people. You're here representing a big company. Now, my question for you is, do you have a right to a government contract?
No, Your Honor, we do not have a right to a
Nobody
contract.
does, right?
Correct.
So what's the basis of your claim? Well, they didn't follow procedures, okay. But the other side is saying the deal, since you have no right, it's not like you've got I don't know what it would be, a due process, substantive due process claim. You got to go through the administrative procedures, and you may win, you may lose, but I'm sorry, you've had this contract for a while and even extended it, and why should we keep extending it because you think they didn't consider this and that?
Your Honor, the claim that we're asserting in this case is the exact claim that the Supreme Court has repeatedly recognized over the years in the City of El Paso versus Heinrich case and the Houston Belt versus City of Houston case, and that is an ultra vires claim. And the Supreme Court has said that we are entitled to assert an ultra vires claim if the commissioner or any other government official acts outside the bounds of their authority, even if they're exercising some discretion in
So
this
how do you outside, I mean, we have this in two of our cases today. We've got a statute that says, well, before you do something, you need to consider this. Consider that. That one, Primexx is in a private context. This is a public. You need to consider this and consider that. How do we enforce that? I mean, do we have to ask the commissioner, did you think about this, or did somebody on your staff think about this? And all they have to say is, well, I thought about it, and the answer is no. How is that justiciable? How could we possibly enforce something that says, consider this before you decide?
So, Your Honor, the particular issue in this case was whether or not the commissioner complied with multiple statutory preferences and requirements that required her to consider or grant preferences with respect to various factors that go into awarding a contract in this case. We conducted a 4-day evidentiary hearing in the trial court on the plea to the jurisdiction as well as the application for a temporary injunction. And at that hearing, evidence was presented which was sufficient to create a fact issue to support a temporary injunction in denial of the plea to the jurisdiction, indicating that the commissioner did not, in fact, consider the statutory preferences and requirements
Did the commissioner concede that? She didn't consider it?
Your Honor, I believe that the commissioner, of course, vociferously opposed it, but
Which raises another problem. It was a different commissioner back then, right?
Right. Your Honor, it doesn't matter whether it's Commissioner Young or Commissioner Muth because
That's not an answer to my question. It's a different commissioner, right?
There's now a different commissioner, but she was sued in her official capacity.
And if this is not this is ultra vires rather than mandamus, but and normally, if it's a discretionary decision, we got to send it back to the new person and see if they're going to decide the same way.
In the mandamus context, yes, Your Honor, but not in an ultra vires claim here. As we mentioned before, she was sued in her official capacity, so it didn't matter whether or not the commissioner has changed over time or not. The bottom line is, at the time this suit was filed, the commissioner gave the testimony that she did, and the trial court based her decision on that testimony.
And
So,
just to be clear, you're saying she said, no, I didn't consider that.
Your Honor, her testimony from the Deputy Executive Commissioners, Kay Molina, as well as James Ramirez, they presented evidence that those factors weren't in fact considered. We also developed evidence that was presented that when the evaluators were trained to assess and evaluate and present and score these bid proposals, that they were not informed about the existence of these statutory preferences and requirements or told to consider them in awarding their scores.
What do we do with the argument that, past performance is kind of the water in which we're swimming, and so we don't need to have a blank that says, past performance, because past performance just, is somehow implicated in everything? What do we do with that?
So, Your Honor, if I understand your question, I think it's in connection with Mr. Scanlon's argument that past performance is a factor that may be considered, and why is it mandatory? And so if you'll look at Exhibit 1, oral argument Exhibit 1 that we provided the court, it lays out the relevant provisions of 2155.144 of the Texas Government Code. They are correct that the past performance factor is under 2155.144D, and that 2155.144D is a list of the factors that may be considered, relevant factors that may be considered. But here, at the evidentiary hearing, we developed evidence that the Deputy Executive Commissioner of the HHSC said that one of the relevant factors in a procurement is past performance. So as a result, if you turn to 2155.144C, it states that the commissioner shall document and consider any relevant factors it considered in the procurement. And since there's testimony that past performance was in fact a relevant factor, they were required to document that they considered it. And it's our position that, again, there's no evidence that past performance was in fact considered in scoring and deciding the procurement in this case.
And all we need here is a fact issue, is that
That's
correct?
correct, Your Honor. It's all it takes. And the trial court issued findings based on more than ample evidence to support her rulings in this case.
So just to follow up on something I was asking earlier, I assume you don't agree that this is an absolute discretion situation, right?
Yes, Your Honor. Here, we believe that it's important to note that we're not quibbling over how just the different multiple statutory preferences and requirements were actually applied. Our argument is that those preferences and requirements weren't considered at all. And that's what distinguishes this case from cases like Hall versus McRaven.
And I'm still trying to hear what you're saying. Are you saying they weren't considered, or they didn't document that they considered them?
It's both, Your Honor. As to past performance, which requires documentation, there's no evidence we submit, or at least a fact issue, as to whether or not it's properly
As to the ones
documented.
that don't require that to be documented?
Yes, Your Honor. For example, with respect to the statutory preferences, where the commissioner was required to give a preference as to a particular factor, we submit that there's no evidence that that preference was actually accorded. And the way you determine that is by looking
I'm
at
sorry,
the,
was actually what?
was actually accorded, was given. The preference was given.
Accorded. Thank
Yes,
you.
Your Honor. And that's determined by looking at what the evaluators were trained to consider and do with these factors, as well as the scoring sheets, which indicate whether or not a preference was actually given or not. And we submit that there is no evidence, or again, at least a fact issue, that those preferences were not actually given or considered.
So back to the discretion piece. I know I keep beating this horse, but how many factors, does it matter how many factors were not complied with? For example, how do we, if there's not absolute discretion, and you go to this list of factors that they shall consider, but there's a documentation requirement, for example, and let's say that's the only thing that was missed. I'm kind of thinking in that situation we wouldn't set aside a huge procurement. How do we know? I think that underscores a problem for us with ultravirus. How do we know when there's enough? How do you know you've now ignored 10 things that they listed? You've now ignored 5 things, 15 things, 50 things. How do you know when looking at a case like this, what is ultravirus conduct truly when there is a large measure of discretion, whether it's absolute or not?
Your Honor, you know whether there's an ultra-virus violation in simply determining whether or not the commissioner acted in a manner that exceeded the authority given, whether it was a discretionary act or not. I think what Your Honor is getting at is how many of these violations do we need to prove in order to establish an ultra-virus claim? Just one, Your Honor. First of all, the trial court said in her order that these lists of violations were singly and collectively enough to grant the relief in question. But, Your Honor, there is no causation requirement for an ultra-virus claim. We are simply seeking prospective relief. We are not asking for damages. We're not seeking to be awarded a contract. We're not asking to undo the procurement. All we're asking for is the unlawful conduct to stop. That is what an ultra-virus claim, and that's the relief that we're asking for in this case.
So how does that going to play out? We start the bidding process over again?
Your Honor, it's up to the commissioner what she does from here, but
What are you're starting out by what you're asking for. What are you asking to start it over again, or to go back and document what they considered? What?
Your Honor, in our pleadings, all we're asking for is the prospective relief of stopping the unlawful conduct from occurring. Now, if the commissioner decides to redo the contract, the procurement down the road, yes, we would certainly be amenable to that. We can't dispute that.
How long does that usually take?
Your Honor, I can't remember the exact timing here, but I think the procurement lasted maybe 9 months to a year, but I may be wrong on that. I'm happy to give you an answer after the argument.
Thank you.
So, Your Honors, I want to go back to a question that Justice Ferris asked, and that is the relevance of Title I, Section 391.309 of the Texas Administrative Code, which states that the commissioner is not required to actually decide a bid protest appeal before moving forward with awarding the contracts. And that's important on one of the central issues and arguments that the commissioner has raised in this case, and that goes to exhaustion. The commissioner and Molina argue ad nauseum that we were supposed to wait until the commissioner decided the bid protest appeals before we could file our ultra vires action. And 391.309 stands for the proposition that if the commissioner wasn't even required herself to decide these bid protest appeals, then it logically follows that we were not required to wait for her to take an action that she might not take. And as a purely practical matter, Your Honor, the reason why there was urgency here and why we had to act is because there was testimony by the commissioner herself during the evidentiary hearing that once she decided the bid protest appeals, she could immediately sign and execute the contracts in question. At that point, after she did that, there is an argument that any relief that we asked for at that point to undo those contracts or whatever would be retrospective, and that would defeat our ultra vires claim. That is a theme of the commissioner's argument throughout the briefs that they filed, which is they are attempting to put us in a box, in a catch-22 situation where if we don't file our suit before the specification protest before the bid proposals were submitted, well then it's premature. But if we wait until after the bid protest appeal is actually decided, then it's too late. Your claims are arguably moot or they're retrospective. And so we acted when we acted, and it's in accordance with Texas law as well, and that's perhaps the most important point that I should have led with, and that is there simply is no requirement that ultra vires claims must satisfy the exhaustion requirement. We cited a number of cases on page 38 of at least the children's plans briefs where courts have repeatedly held that ultra vires claims are an exception to the exhaustion requirement, and indeed in many of the cases that Molina cites and the commissioner cites, the courts have held the same. But more importantly, there's a general proposition of law supported by the Supreme Court that when you're asserting a common law claim, unless there is a statutory exhaustion requirement, then there is no requirement. And here, there is no statutory exhaustion requirement saying that you can't file an ultra vires claim until you complete the bid protest appeal in this case.
I think the underlying concern here is just, and it's not, something that the parties have created, it's just the development of the case law. Ultra vires is just becoming so pervasive that we don't want to be, stepping in and, freezing everything all the time for people to kind of go around the administrative process for things that truly should be resolved through the administrative process. Is there some line that you would have us draw for why this would be a permissible use of ultra vires, but, we're not going to be back here every time any new procurement comes up?
Your Honor, let's assume that, to answer your question, I'm not sure that there's a bright line we can draw because honestly, I think it depends on the evidence presented. And here we were presented with a situation where if we waited until the commissioner decided the bid protest appeals, we faced a situation where we had to file our ultra vires claim, otherwise face the inability to assert it once and for all. I think you just have to go back to basics, Your Honor, to put it bluntly. The requirements to establish an ultra vires claim, to be candid, are somewhat strict. You have to prove that the commissioner not just simply violated any kind of statute, but violated statute that is connected to the scope of their authority. We believe we've satisfied that requirement in this case, but we don't think that all bid protesters in the future will be able to. Thank you, Your Honor.
Thank you. Mr. Grossman, is that correct?
That's correct, Your Honor.
Proceed.
Good afternoon, Mr. Chief Justice, and may it please the court. I wanted to start by emphasizing what it is that we're here on and why that matters. We're here on a temporary injunction and the denial of a plea to the jurisdiction. And why that matters is because of the standard of review that's applicable there. We have 13 separate legal violations found by the trial court and 4 separate plaintiffs. For HHSC to prevail, it needs to demonstrate that not a single one of the 4 appellees demonstrated a likelihood of success on a single one of the 13 legal violations the trial court found. And Your Honor, I respectfully represent that's a burden they cannot possibly meet here.
So at the hearing, they point out that the complaining parties all scored much lower than the parties that were selected for this, for these programs. Did the temporary injunction cover whether there was something wrong with those scores other than the commissioner didn't consider this or that, or didn't document that they considered this or that?
Your Honor, I'll hit on 2 points there. One, I think the representation that the complaining plans all scored much lower simply isn't true. With respect to my client, Wellpoint, we were the 5th highest scored of the 18 bidders. We received awards in numerous contracts, or in numerous service areas. We're here because we want the commissioner to follow the law.
And you want a few more of the contracts.
We certainly would not object to receiving them. But I think circling back to your question, really the complaint here is not so much about the scoring. And when you look at the different statutes that we're here on, that's a helpful explanation of why. A lot of the statutes require that the commissioner shall give preference to various things. Respectfully, there is no discretion in those. She does not have the discretion to choose not to give preference at all. And what the trial court found was that on those preference statutes, that's exactly what she'd done. That there was no evidence HHSC could present suggesting that that preference had been given. That their own testimony was that there was nothing you could look at to see where that preference was given.
But isn't the nature of preference also a little bit discretionary? It's not like a must award, must win. It's a preference, and
So certainly HHSC has discretion in what the preference they give looks like. They do not have discretion to choose not to give the preference at all. And that's what the evidence below suggested happened here. These contracts were awarded based on scores. The scores came from evaluators. HHSC's own testimony is that they never told the evaluators who were giving those scores that the preference existed or should be taken into consideration. There's no way that HHSC with a straight face can suggest that someone who did not know that the preference was supposed to exist in the first place gave the preference. And I did want to circle back to one question that you all asked earlier with respect to, did the commissioner admit that she did not consider past performance? Yes, she did. One of the things that you see in the record here.
You wouldn't be able to give me a cite for that.
I do not have the page site, although we can certainly provide that.
Send that in later.
We can send that in later.
Better
but,
for you to look at for it than for me.
Yep, but one of the things that's in the record is testimony that the commissioner gave to the legislature. And her testimony to the legislature was that HHSC did not consider past performance. She certainly tried to come back in the hearing and suggest that yes, she did, but at a minimum, her own conflicting testimony creates a fact issue, which is enough for this to move forward with what we're here on today. And along those same lines, the Supreme Court's case law on ultra-virus claims makes clear that where there's an evidentiary question, the weighing of the evidence is for the trial court. Houston Belt says that. As long as there is some evidence that she did not comply with these statutes, and as we just covered, there is a great deal of evidence that she did not comply with those statutes, that's enough to defeat the plea to the jurisdiction. And it was enough for the trial court to find that there was a likelihood of success on the merits to sustain the temporary injunction. Circling back to one other thing that you heard from the appellant's counsel, that they suggest that the right time to bring this claim would have been before the bids went in. Wellpoint submitted a pre-bid protest on one issue. That they argued that the award of mandatory chip contracts would clearly violate the statutory scheme. The commissioner's response was that Us filing it at that point was premature because we didn't know whether we were going to win or lose yet. And I think that's illustrative of the box that the commissioner's trying to put the plans in here. The commissioner's position is that any complaint a bidder may have as to whether she's following the law is premature right up until the moment that it's too late. That there is no sweet spot that the commissioner believes exists that we could actually bring these claims. And that's why we have to act now, because if we let her execute the contract, we're going to be faced with her arguing, well, now there's no relief you can get.
What do you make of the argument that really your only remedy here is to go take this up with the legislature and see if they'll give you a right to sue?
I don't think that that's supported by Texas law. There are a number of Supreme Court cases that are cited in Wellpoint's brief that say that a citizen or a litigant does not need the legislature's position to ask the state of Texas to follow the state of Texas's own laws. That's sort of the theory underlying the ultra-virus claim. And I don't think there's any basis for the court to back away from that. I will agree with my co-counsel that there may not be a bright line that we can draw here, but I think there certainly is a line. We're not here quibbling about whether a timing requirement was complied with. We're dealing with statutes where the legislature has expressly said when the commissioner awards Medicaid contracts, she has to consider these things. Where the commissioner has decided, I don't want to consider these things.
Well, I'm looking, I mean, some of them say that, some of them don't. 0204 says you got a commission shall consider different plans to meet different populations, consider the ability of the organization to process Medicaid claims, and give extra consideration. I'm not sure what's the difference between consideration and extra consideration, but they say give extra consideration to continuity of care and all that stuff. Well, how in the world is that justiciable? All the respect in the world for the trial court, but the trial court cannot decide whether the record supports that or not. We defer to the agency for those kind of calls, generally speaking.
I think the one thing that the trial court can consider, and maybe this is the bright line we're here on, when there's no evidence that the commissioner did it at all, it's not difficult for the trial court to draw that conclusion. And that brings me back to my point that I began with, to prevail, we just have to show that we had a likelihood of success on any of those claims, and at least the ones that say that the commissioner shall give preference to. The question of did she or did she not follow that is not a hard one to resolve.
Thank you, Mr. Grossman. Ms. Walker.
Thank you, Mr. Chief Justice. May it please the court. Justice Ferris, I'd like to start by addressing your question about why won't we be back here on ultra-virus claims on every procurement matter. We won't, because this is not a typical procurement matter. The managed care plans do not compete based on price. The state sets the price. That makes the other factors even more important. And here, this is different because the legislature has enacted statutory provisions that apply exclusively to Medicaid and CHIP contract awards. And those statutory provisions direct the commissioner to do certain things, including that she shall give preference to provider networks that are existing at the time, as well as to whether the plan has successfully implemented quality initiatives. And it does those because the legislature obviously considered those things important for the commissioner to do in awarding these critical contracts that will affect the lives of millions of Texans. And after 4 days before the trial court, what the evidence overwhelmingly shows is that the commissioner has noticed her intent to award Medicaid and CHIP contracts while disregarding those statutory mandates. And by the way, the legislature, when they recently reenacted those statutes and moved them within the statutory provisions, they left those mandates in there. They're still there. And so she is ignoring those. And just to give you a couple examples of the evidence below with regard to the preferences, the evidence shows that the evaluators were not told to look at existing provider networks. They were not told to apply a preference. They were not even told that a preference existed. So there's no way when the commissioner based her awards based on the scores the evaluators gave that there could be a preference.
So just going I'm following the argument on that, but I guess taking it 2 steps further, then isn't the only way to fix that a new procurement, which is not what is being specifically pleaded for, or?
Well, Your Honor, what we're asking for, this is an ultra-virus action for injunctive relief to stop the commissioner from doing something that's going to exceed her authority and conflict with law. We're asking that the court enjoin her from proceeding with the contract awards that she has noticed. She has said what she intends to do. So,
I hear you,
yes.
and you're doing the best you can with a strange statute, but I'm just, what do we do, you know? I am reticent to be the court that says, great, we've disregarded getting a new procurement for 2 years, let's do it for another couple of years, go back, and this time have a checkbox where you check off all the things that was in the temporary injunction, and then is that all we're here for? That what you need is the commissioner needs to have a checkbox where she can check off all these things and then do whatever she wants, because she does have a lot of discretion here. She determines, and best value, you know, that may or may not fit with veterans' preferences or whatever. That's not particular here, but various other of these preferences. Is that all this is about?
No, Your Honor, this is about the commission.
Great health care, I know that, but actually it's not about great health care. You're not here telling us that you all are a better health care plan. You have not told us that in your brief. You didn't try to prove that, and it would be, I don't think courts would be any good at trying to decide that. You're telling us they didn't have the check boxes checked.
It's not just check boxes, Your Honor. It's statutory provisions. The legislature has put those statutes.
Sorry, statutory check boxes.
And I'm not sure the legislature, when they enacted those, would consider them check boxes. They put them there and they use the word shall.
So it's not like, it's not may, it's the shall word that,
Shall consider.
I'm focusing, no, not in the 533-003.
And one, and all the rest are shall consider, which a checkbox would show, I considered it.
With regard to the preferences, and I want to focus on the preferences, again, any of the findings from the trial court support the court's order, but I'd like to focus on the preferences. In those statutes, and I'm referring to the statutory provisions that existed in the record at the time, I know they've been moved.
Right.
But 533-003 talks about when, it says when awarding a contract, the commissioner shall give preference. It doesn't say may, it doesn't say, so when she is awarding a contract, and not just any contract, a Medicaid contract for 533-003, she is required to give a preference.
But again, we're going around in a circle here. I'll give you some time back, but this is where I'm caught in a circle. Then if I press you on that, everybody would agree, you know, a veteran's preference or, you know, this, that, you know, economic disadvantage preference. Doesn't mean all the veterans or economically disadvantaged people get into UT Law School. It's something that if everything else is exactly equal, then we do the preference. That's really what a preference is. But then whenever I say that, well, it's just, they have to be exactly equal. You say, oh yeah, but there's no evidence she considered it, and we're back to check boxes.
Well, Your Honor, no, I'm not saying there's no evidence she considered it. She did not consider it, but there's no evidence she gave the preference. And the preference here just says she has to give the preference. It doesn't say when all things are considered equal. The legislature has done that in other statutes, and it is cited in the briefing of the commissioner. 2155-444 is an example where the legislature said when all other things, price and quality, are considered equal, you have to give a preference. That's not what the legislature said here in 533-003.
Does this any of the preferences you mentioned override best value?
No, they don't override, but she has to give a preference. If she had given a preference, we wouldn't be here. A couple reasons why we know she didn't give a preference. Melina got the highest score in the quality question that Mr. Scanlon referenced. There's evidence in the record, it's Exhibit 69, where HHSC says Melina gets the lowest quality scorecards, scores of any plan in all but one of the regions it operates, and it doesn't meet minimum performance standards in any of the areas where it operates. It got the highest score on quality. They did not apply a preference. With regard to the provider network preference, there's evidence in the record, and it's Exhibit 283 of the plaintiff's exhibits, that shows that Blue Cross Blue Shield got the highest score on what they claim is the provider best value criteria and they were awarded a contract in Hidalgo County. There's evidence in 283 that shows they have 0 hospitals in their network at the time of that contract award in Hidalgo County, and they have 0 federally qualified health centers. They could not possibly have met the preference requirement in 533-003, but yet they got the highest score. There was no preference given. The evidence is overwhelming below.
You can take another couple of minutes, because I took up so much of your time.
Sure. So the court should reject the commissioner's argument that she can ignore what the legislature has said she must do. And it should also reject the commissioner's argument that basically no court can review her action. The reason we have ultra-virus actions, it's a safety valve to make sure that a public official complies with the law. When you have a public official that's ignoring the law, that's a problem. That's why we're here.
So address, if you would, the last exchange I had with Mr. LaFond of where they want to say there's no ultra-virus because there's exclusive jurisdiction. Could you go ahead and address whether there's exclusive jurisdiction in the commissioner here?
There is not exclusive jurisdiction, and the Aspire case is very different than this case, simply because the legislature has given the commissioner authority to adopt procurement rules in a protest procedure doesn't mean there's a pervasive regulatory scheme. So there is not exclusive jurisdiction here. And there is case law saying that where there is an ultra-virus action, that you don't have to exhaust administrative remedies. And that's why we're here. And we would ask that you affirm the court. The trial court correctly denied the plea to the jurisdiction and did not abuse its discretion in entering the temporary injunction.
Thank you, Ms.
Thank you.
Morgan. Mr. Scanlon? Has somebody told the commissioner next time she needs to check the check boxes?
I think
That may be attorney-client privilege, but for crying out loud, did they check the check boxes that the statute said they needed to check?
the check boxes were checked, Your Honor. The RFP incorporated every one of those statutory provisions. They were set out in the best value criteria. The bidders had an opportunity to explain, and I believe it was 7 to 10 pages in their proposal, how they would qualify for a preference. And then the evaluators, who were trained on those best value criteria, took their presentations and scored them and decided who was going to win the award. That is a matter completely within the commissioner's discretion
But
to choose a winner.
can we match up the statutory requirements and preferences and shall considers to the score sheets?
Yes, you can. You can match the.
Is that in your brief somewhere, or?
It is explained at length in the brief. This is a bit of a technical requirement. Today, I would highlight the 536.052 preferences on quality initiatives, where I think I quoted technical question 13 to you earlier, how it talks about quality improvement, performance evaluation strategies. The language is substantively gives the effect to all of these statutes. We've explained that at length in our brief.
Could I ask you a question just on the nature of ultravirus? And I know you'll tell me this is not this case, but if, hypothetically speaking, you had shall consider, shall document, that undisputed testimony absolutely did not happen, still no ultravirus in that scenario?
So in that scenario, if you have an official where they have completely disregarded the statutory requirements, that would be remedied through the protest process. You would have an RFP that sets out the rules. You'd have a conduct where that's not been applied. And if the commissioner was going off the rails, there are oversight, internal checks to that. That would be the remedy.
Yeah, but let's just say, taking her question and going further, let's just say that we're not buying the exclusive jurisdiction argument, so you get a ultra-virus claim. Now answer the question.
So if you're not going to find that there's exclusive jurisdiction, the court should still find that the claim's not ripe because the protest process wasn't followed. Ultra-virus requires them to show that we exceeded the statutory authority right.
But what I'm hearing is, whatever you do, don't decide ultra-virus, because we have all these other reasons.
That's the case that they've brought. They've asserted that they are trying to enjoin the contracting process.
No, what she's asking, I think, I hate to say what you're asking, but you tell me if I'm wrong, is that ultra-virus conduct? And you're saying, well, it's not ripe. Well, I'm saying, well, assume it's ripe.
Assuming it's ripe, it would still be retrospective under the facts of this case. And I understand.
I'm not asking if there's a remedy. I'm asking, is it ultra-virus conduct?
It's always ultra-virus conduct if they're not following the statute,
Which
but
is
you have to
answer to
meet
your
all
question.
the requirements of that. Chief Justice Brister, you asked how long the procurement was undergoing. This process started in 2019. It's been many years that this procurement has been going on, and the trial court undid that in 4 days. The legislature also had a chance to address how this would be remedied. They made no changes to the statute. This case was abated so that the legislature could decide whether there was going to be a fix here, and it took no action on these statutes other than, the non-substantive recodification. So the legislature's shown what the remedy is supposed to be here. The fact that they haven't pled a viable ultra-virus claim shouldn't, I think another point that needs to be made, though, is that if we accept their position that you can sue without exhausting the protest process, you are going to see many incumbent bidders especially suing the agency as soon as they get a whiff that they're going to lose a contract. And that clearly is not the result that the legislature intended. They made the point about, we talked, I think, too long about past performance. Again, it's a may consider factor. And I would also give cites to James Ramirez's testimony, volume 5 of the report of records, page 227, where he said that if you are asking me whether it's relevant, you have to look at what it says in the RFP. The RFP is the driver of what's a relevant consideration. And if they had a problem with how it was going to be implemented, they were obligated to protest the RFP. None of the protests in the RFP said anything about that. The only one that was made that's arguably before the court today is Wellpoint's protest about bundling CHIP and STAR. And that's just unmeritorious on the face of the statute that applies, which says the commissioner may prefer MCOs that provide similar coverage under Medicaid in awarding CHIP. And again, that's just a flagrant incorrect statement in the TI. So there are plenty of grounds for reversal, but we think that you shouldn't have to look at all of the evidence from the hearing. If you look at the pleadings and read these statutes on their face, they provide the discretion to do what they're alleging that the commissioner has done. So if you do reach the evidence, none of it creates a fact issue. None of it creates an issue that says that the commissioner exceeded her statutory authority or used her discretion to exceed her statutory authority. What happened at the hearing was just an improper exercise in burden shifting. They would get agency witnesses on the stand. They would have them concede that the statutory factors weren't applied in the exact way that they demanded, and therefore that was somehow an ultra-virus claim. Again, they haven't brought you anything to show that the statute was violated here and can be enjoined as ultra-virus in the first instance. I think with that, I would yield my time.
Thank you very much. Thank you, ladies and gentlemen. The case will be submitted. We'll take a 10-minute break, and then we'll be back for the next case.
All rise.
seated, please. Court calls Blackstone Holdings versus Primexx Energy Opportunity Fund. Who's present for the appellate
David Cole for the appellate, Your Honor.
and for the appellee?
Ryan for you.
All right, 20 minutes per side, reserving some time.
5 minutes, please.
Okay. Proceed.
Afternoon. May it please the court. I'm the warm-up act to a pretty significant question of corporate governance in the next appeal. This is obviously a more niche item. And so I want to speak to one aspect of it. I think it's the key aspect of this appeal.
Don't downplay it. There's some of us that love personal jurisdiction
Well,
cases.
in that case, I'll savor every syllable. It's a way to think of personal jurisdiction law, Justice Brister. It's like a checkbox, and you want to just make sure you have all the issues covered.
Very nice.
But now I've logged that one. So the issue I wanted to speak to is this question of waiver, because there's minimum context issues that honestly I think are well set out in the briefing in both appeals, and we can spend our time in other issues. But the question here is an issue of construction of a very basic rule. It's been around a long time. There are surprisingly few cases. Rule 120A tells us you can make a special appearance for an entire proceeding. And our Supreme Court, this Jaster case that we cite, did an exhaustive review of cases that use the word action, proceeding, cause of action, claim, categorize them in any number of different contexts. And this is not in the briefing, it's not in the cases, but my suggestion, having looked back at it fresh for this argument, is that an action, a proceeding, has two properties. They recur in those cases, and they explain the cases that were cited in the briefing on this issue. It has a separate cause number, it's a separate procedural entity, and it is capable in its own right of producing a final judgment. Though it's not perfect, but I think those factors make some sense out of those cases, and they make sense out of the precedent that's been cited to this court. For example, there are, I think, 3 cases in Texas that have dealt with this rule. They are readily reconciled using that approach to things. We have one, this Sejas case, where someone moved to dismiss earlier lawsuit ends, new lawsuit is filed, they raise a special appearance. That's a separate action because it's a separate cause number, and the final judgment in that case would be distinct from whatever happened in the first case. Waterman Steamship, which we believe to be the most analogous case, same thing. There's a separate cause, there's a later lawsuit, and there is a motion filed. This Massachusetts Bay case, which is the contrary case, deals with the same case. It was an action, it was consolidated into a later MDL, it became the same case. It simply had a way station along the way, easy enough. There is a distinct definition of what an action is, and this break in all these different lawsuits over time means it wasn't the same action, which means we now no longer are really looking at Rule 120A, we're looking at rules of estoppel. There are a couple of different estoppel doctrines that my opponents cite. That's how you can tie 2 distinct actions together. It has nothing to do with the rule. It's just what estoppel doctrines do. And
What is the best Texas Supreme Court guidance for us on this judicial estoppel?
So there's not really a Texas Supreme Court case. It's scattered all over the place in the courts of appeals. And there's unfortunately an unsettled question as to whether it has to be under oath in the first action. The precedent on that is scattered in the courts of appeals. I don't think the Supreme Court has resolved that decisively. So I don't think we have the good fortune to have an on-point Supreme Court case, nor can you really have one. These judicial estoppel cases tend to involve all sorts of case-specific issues. Consistency, though, is the question. And again, there's not really, I don't have a case about this particular fact pattern, but I do know our position's consistent. I mean, the position we took in the initial action was about them. We said, you are bound by this agreement. It requires a certain way to proceed in the lawsuit. And that doesn't have anything to do with us being bound by it or being a party to it or any of the other things that they claim. It's consistent with our position here that you don't have, you have the claim you have, and we don't have any business being part of it.
You did ask the court for some kind of affirmative relief. Get
Right.
rid of the case and let us
That's
go
true.
in federal court, right?
And not in that action, of course, right? That's where we go back to the rule. That request would have no effect
Well,
on later
only because
action.
you can't transfer.
Yeah.
If the transfer, if it had been a form selection to state courts in El Paso, you would have transferred it, but you can't transfer from the state court to the federal court. Why should that be a different
Well, because in terms of what the rule applies to, it's a different action. It's a different cause number, a different procedural device, different judgment. In terms of estoppel, request to transfer is not an estoppeling thing. It doesn't create an estoppel. Estoppel has to be a statement of fact, a statement of position. A request for relief is, at best, some kind of a legal argument, but that doesn't create a judicial estoppel. It doesn't create an admission in that action.
So I understand that argument, but when you agree to the thing that puzzled me about this, I may have missed it, but when you agree that exclusive jurisdiction will be in the federal courts in Dallas, Texas, why have you not waived objection to being hailed into court in Texas?
Well, the exclusive jurisdiction, if there is jurisdiction, right? I mean, people have forum selection clauses all the time to dispute personal jurisdiction and other issues.
Yeah, and my understanding, are you saying my understanding is wrong? If you agree to exclusive jurisdiction in Missouri, you can still come back and say, oh, no, I never agreed to jurisdiction in Missouri?
I've agreed that of all the places where there could be jurisdiction, it'll be Missouri, but I don't agree that you can bring any crazy thing in Missouri that any connection to that case. I mean, different wording could achieve different things, but this clause is just of the places it can be filed, this is the place. It's not a mandatory consent sort of thing, and that's not the argument they're making either against our position.
Let me make sure I understand what you're saying, though. Let's assume that we are on appeal from the very first action filed. Had your client filed that same motion to dismiss, and then, let's say it was denied, and then you file a special appearance, are you saying that first filing would not have waived the special appearance?
It could have. I haven't run that all the way through, but the argument would be stronger than in this case. Could you be in the same action? And then
Right.
the order of pleading rule would kick in, which of course has nothing to do with being in separate actions.
So to follow your argument, you're saying that's the 120A argument because we're not in the same
Right.
proceeding. Then you have to look at it from an estoppel perspective.
That's right. You look at the judicial estoppel thing. And there the question, judicial estoppel and Rule 120A come from different places, right? Judicial estoppel is this much farther reaching thing that you can't trick somebody into doing something here and then move positions later on. It stops shifting of positions. And
Does it
that's-
matter that you are, basically, I know it's the fourth proceeding technically.
Yeah, there's no lot of.
But you've got the same basic parties, same basic facts, and same basic claims, right?
It's similar as they were in the other two cases that have gone our way as close there's been. I mean,
Does that matter?
Well, as to the action part of it, it could. I mean, if you have the same parties, at some point, you start looking a lot like the same action, except for the problem of the cause number and the judgment that I identified earlier. But those are warning signs that you're heading into something that's probably the same action. In terms of estoppel, I don't think so. I mean, estoppel asks, is it the same person? We have to be the same people. But it isn't necessarily the same person on the other side of it. The question there is, has some court in some way changed position?
Well, is there any risk that we would be creating kind of opportunities for procedural gamesmanship if we go down this road?
I mean, there have been 3 cases on this aspect of Rule 120A in the history of Rule 120A. That rule's been on the books as long as there's been special appearances in Texas, so it just doesn't come up very much. And if the problem here is mischief, I think it's the other way, because the rule says action. It doesn't say closely related action or any number of other things. And so I think the risk of problems is greater if action actually means something other than what I suggest it means. So the risk is low either way. This is a little bit of a one-off, but given, you know, where the case law has been compared to where it could go, I would suggest that we stick with action and try to keep that consistent with what the cases have generally applied it to mean.
So what do you do? Somebody files identical claims against you, one in El Paso and one in Beaumont. You decide, I don't want to be in Beaumont, I want to be in El Paso. So you file a special appearance in Beaumont and you go ahead and litigate in El Paso. We can't let people just pick and choose.
Goodness gracious. It's, Yeah, so I'd be against the same people, I suppose. There'd be, I mean, the cases would likely be consolidated at some point, and somebody's going to request a transfer. And the chance you have two cases just going in isolation like
You're
that would be
dodging,
hard
you're
to believe.
dodging my hypothetical.
Well,
I can tighten it up.
I'm
if you
I'm
want.
questioning whether that would, I mean, I get it, that could but that didn't happen in these other cases.
Right, well,
One
but
case dies or
You're
they
s-
get MDL.
But you're saying it's an entirely different case. Yes, it's exactly the same parties, same claims, same everything, but it's an entirely different action. So that one, we appeared in because we wanted to get a transfer venue, but when it was refiled again, we didn't appear in, and so we are okay to file a special appearance. That looks like picking and choosing.
Yeah, so that's the fact pattern of the two cases I led off with, is there were two actions, one ended, a new action began,
My
somebody raised a special
recollection is, though,
appearance.
there's cases going both way on that. I mean,
there's-
one of the minimum contacts is, do you litigate cases in Texas?
Right, that's true. You can consent, obviously, to jurisdiction in Texas, but that's a different question here. The Rule 128
I don't
question is,
see
is
why
it
that's a
action?
different question.
Is it
You
the-
showed
yeah.
up and litigated exactly this case. Didn't litigate it far, I'll concede,
Yeah.
but you showed up and appeared and filed, file an answer, or you have to file an answer to file a motion
We
to
filed a lot of
transfer venue.
things. The record shows a motion, we filed a special appearance, we filed a motion to transfer, we filed special exceptions, we had a lot of quarrels with their pleading.
So you filed a special appearance in the first action?
Yes, it didn't get heard for whatever reason, but it was resolved, that there was one on file.
It has to be heard first, doesn't it?
Yeah, right, so it's just neither here nor there. It's in the record, but it's not relevant to your hypothetical. But I just wanted to show off that I knew it was there.
Okay, all right, that sure looks like,
Look, there's two different things going on here. There's
I
the
mean,
def-
you thought you could beat it the first time, not you personally, of course. but
Look, there's the-
somebody thought they could beat it first. So the deal is, I get to interrupt you, you don't get to interrupt me. When you become the judge, it'll be different rules.
I'm just
But for
wanted to
this,
talk to you.
for today, humor me. So it looks like, you showed up the first time, oh, we can beat this, we can move it to federal court, and it turns out you couldn't move it to federal court. And so you come back, okay, well, now we'll say we're not subject to jurisdiction. That looks like you're just picking and choosing.
So Rule 120A says action. That's the rule that defines what we're doing here. Could I do something that creates an irrevocable consent to jurisdiction forever based on what I file in the first lawsuit? Possibly. There's a body of law about that, about waiver and consent. No one's arguing we did that. To the extent the due order of pleading rule is what we're talking about, it's cabined by an action. To avoid, I think, exactly this question, because if you pose that question, and that becomes the rule of decision, something in addition to just the word action, then all of a sudden, there's all these interactions between cases that can become the subject of discussion that have
And
not
you're-
been for years.
For action, you're relying on, I'm not finding the word action in 120A.
Proceeding, I'm sorry. It's proceeding, and the Jaster case in the Supreme Court talks about the interaction between the word action and proceeding. So the rule says proceeding. It's a synonym with action under the Supreme Court's Jaster case. So that's
Are we,
why I've been using that.
are we cabin to 120A and estoppel? I mean, back to the Chief's question, I don't understand fully why, if it's the same party, same underlying claims, and a party seeks to have jurisdiction enforced in Texas, why wouldn't that be enough for a trial court judge to find at least enough evidence of consent to proceed in that forum?
Well, there's law out there about consent, and that hasn't been held to be enough. It's all been handled under this due order of pleading issue, which I think is dealt with. Also, too, remember what happened. We non-suited. And there's another body of law about that when that happens, everything is as if it never was. I mean, there's no issue preclusion effect from us filing the special appearance. There's no claim preclusion, or the motion to transfer. There's no claim preclusion effect. It just goes poof. And so if it goes poof for those purposes of what a final judgment can do, it doesn't seem like it would be the basis for some sort of
Well,
irrevocable
that-
consent to
again,
jurisdiction.
That's one of those rules that, in context, that's exactly what it means. But if if you had an person who was not an attorney who filed it, the claim, and then the unauthorized practice committee goes after them, and you non-suit it, it's not as if it never happened in that case. So it depends on the facts, the context.
True point. But it's a reference point here, right? We're trying to figure out what was the effect of those pleadings. That was something material that happened, and it does bear with it probably way more case law about what the effect of a non-suit is than any of these other issues about this guy filed suit here and this guy filed suit there. That's as good a starting place as any. And by the way, that's the end of the other estoppel argument they make, collateral estoppel. It says you can't non-suit something and get out of the effect of a final judgment, but of course there was no final judgment in the first action. It just went away. So collateral estoppel, claim preclusion has nothing to add to this except that the absence of it is a telling addition to the question of whether a waiver occurred. With that, I'll give the court my 17 seconds as apology for having interrupted.
Thank you, Mr. Cole. Mr. Caforio, is it?
Yes, Mr. Chief Justice. May it please the court, I'd like to touch on a few things here. This case is properly proceeding in Texas court against these entities under either waiver or estoppel, or actually minimum contacts, which the court below didn't reach with regards to these entities because it found they had submitted to jurisdiction. So first, with regards to the idea that a forum selection clause does not actually confer jurisdiction in this court, the Texas Supreme Court has said the exact opposite. The case on point, there are many, but Michiana, 168 Southwest 3rd at 792.
That's a great case.
Yeah, correct. Well-written, well-analyzed, a very nice opinion. And it said in a well-structured sentence, a forum selection clause operates as consent to jurisdiction in that forum. And so what we had right here, and I do want to be clear in the record here, and maybe they can point something out, but there was no special appearance filed in that first proceeding. There was a motion to dismiss, and there was an answer. And they sought specific relief, affirmative relief from that court, which they got. And you can look at the motion that they filed, and it is, now there are two clerk's records because we have two appeals, so I'm going to cite everything to the same clerk's record, which is for the second appeal. But on page 3074, CR 3074.
Let me get that straight. The first action and is it the third action, the clerk's record is identical?
No, so I'm saying the two appeals we have today, they're actually different CRs. The pages are
Do we have the first action record anywhere?
I don't know that it was broken up in that respect. We have all the filings from that action.
Somewhere in our record.
Yeah, and that's what I want to cite to right here, is in our current, in the CR that we have for the second case you're going to hear today, because I didn't want to bring in 10,000 pages. So in the CR that you have at page 3074 is the motion to dismiss that these entities filed in that first action. And they said, quote, the claims are within the scope of the foreign selection clause based on the plain meaning of the provision. They then said on the next page, those claims can only rely on the partnership agreement, thus enabling the affiliated Blackstone defendants to invoke the forum selection clause. The court then granted that motion and sent the court to the Northern District of Texas. Our argument was there's no subject matter jurisdiction in federal court. There's no diversity. There's no federal claim. Let's keep it here. They sought that affirmative relief, and the court said, yeah, the federal court needs to determine it doesn't have jurisdiction. We filed an identical claim. Sua sponte, that court said, there's no jurisdiction to hear this. You got to go back to the state court. So we filed the identical claim again, but we added one defendant, the individual. And once it came back, it was put to a different district, a different court. And so these parties moved to transfer it to the same one that the original proceeding was in. And they said in that filing that this is, quote, this is in the CR 3097, and they said on July 31st, 2023, plaintiffs filed the instant action alleging the same claims against the same parties arising out of the same transaction as the first action that the 298th District Court previously dismissed. That is, plaintiffs have once again asserted contract and fiduciary duty claims against the Blackstone defendants, PEC and Mr. Doyle, while also adding one additional defendant, Angelo Acconcia, arising out of the sale of Primexx Resource Development, AAC. Indeed, many of the allegations in the instant action are word for word verbatim of the allegations in the first action. And then, after that case sat there for many months with nothing happening, the parties agreed that we would take it over to the business court and see if we could move things a little quicker. And here is a filing from defendants that the language here is pretty intriguing. This is in the record at page 3107, and it is a notice of related case. And page 3107, they say, the above referenced case was filed on July 31st, 2023 at 5:15 p.m. in the 68th Judicial District Court, making it the third filed case of this litigation.
Well, I guess, what does this mean, though, for the future? So, I mean, typically, when we're looking at a special appearance, we're not, like, going and looking at what's happened in other cases. Does this mean that from, this point forward, when multiple lawsuits are filed, we're always going to be having to check and see what some other court is doing or what's going on when we've got a special appearance in front of us?
No, because you have the business court, the trial court, who looking at the facts said, this is identical, this is the same. They put in their own notice, this is the same litigation. And the three cases that my esteemed colleague pointed to all lead to the same outcome. Their best case is the Ford case. They rely on that a whole lot in their briefing. And the real key difference in that case was that Ford, in the initial litigation, never consented to anything happening in Texas. They said this case can only proceed in Mexico. It can't proceed in Texas. So it got sent to Mexico. 7 years later, they came back, and then they filed a special appearance, and the court found you didn't appear generally, you never said Texas was the right state.
Let me switch gears on you for the, I'm also offended that neither one of you addressed Cornerstone Healthcare versus Nautic Management. I wasn't a judge on that one, I was just an attorney. It's 493 Southwest 3rd 65. And the Texas Supreme Court says, so this has a lot of analogies to your situation. This is what funds do, investment funds. The money's all up here. We find something to do, so we create a general manager of a general partner, of a limited partnership, of a local, and then we have the, there's a term for it, the companies, the...
a single purpose entity?
The actual investments, and they're the ones that have all the assets.
Yeah.
And so the question was, can you get these people who were in Rhode Island in that case? Now, a little different case because it was they targeted an investment, a corporate opportunity in Texas, and they took it, and they set up all this thing to do it. And the Texas Supreme Court says, no, you can sue them all in Texas because nobody else made the decision to acquire these hospitals other than the funds because nobody else had the money. I mean, that's who made the decision. If your people up here, the Blackstone people, and I assume those are the ones that have the money, and they made the decision to, now this may be a little different. They didn't make the, this wasn't the setup, this was the end. It was the other end of it was the burial process rather than the birth process. And so, but that's who is driving this ultimately, and obviously, I mean, that was the argument in that case was, yeah, but we have all these different companies and you can't just tie them all together, and that's normally true. But if you just created them, if that's the ones with the money, then that's the ones who targeted Texas with its decision to sell or whatever. So I don't expect you to know that just off the cuff, but I would appreciate your comments on that because it does look like If you all were the ones with the money, and you all were the ones who gave the money, and you all were the ones who got all the money, the funds did. That's what the funds do. Why is that not a minimum contact with Texas?
Well, and we certainly submit that it is, and that really comes up in the second appeal we're hearing today with regards to Blackstone, Inc. and Mr. Acconcia, who they aren't subject to this waiver finding because they were not defendants in the first action, so they didn't actually waive. But I think that's exactly correct. When you look at the factors of what it means to purposefully avail yourself to doing business in the state of Texas, to taking advantage of the state of Texas, from the top, and then every entity created on the way down. And there's a, we put the chart of each entity, it's the managing partner of the managing partner of the sole member of the, it goes all the way down. We have that in there. And they decided to put a few $100 million into a Texas corporation that owned real assets of Texas oil and gas. There were no employees up the chain. This comes in through Mr. Acconcia. It was all controlled by Blackstone, by him. He oversaw the process. He made the decisions. He oversaw the board while they were, conducting business. One of the arguments they make with regards to Mr. Acconcia is, well, there's no evidence that he actually made any decisions that were happening in a Texas board meeting. And if you look at CR 524 through 526, it's the minutes of the board meeting where they approved the sale in Texas of Texas oil and gas assets to another Texas company that Mr. Acconcia attended and voted to approve that sale.
Which raises another question, since that isn't addressed in our briefs, because the business court did not rule based on that basis. If we find against you on the waiver or previous litigation in Texas, do we need to remand or address those points?
Yes, so I think technically you would probably need to remand. We were not allowed to take jurisdictional discovery with regards to these entities. We did take limited jurisdictional discovery with regards to Mr. Acconcia and Blackstone, Inc., after these entities were already found to be in the case through their waiver. But if the court didn't find waiver or estoppel, and if it didn't find that the record already had enough in it based on the arguments that were presented in the business court in the first instance, that chain up the command exactly as set forth by the Chief Justice, then we should be able to take jurisdictional discovery to establish those facts.
And remind me, this case, part of this case is still pending in the business court?
So it was a partial grant of summary judgment. There were some claims remaining. The parties agreed because what was granted was such a key component of the case that we would voluntarily dismiss those remaining claims without prejudice to refile with regard, once we got a ruling from the business court regarding the other claims. With regards to the estoppel component, so first we think it fairly directly fits into waiver. 120A talks about a whole proceeding, and every time it uses language, it talks about whether or not the party is amenable to service of process by the courts in this state. It's not so limited with regards to it has to be a particular cause number. We know that's not the case because of Massachusetts Bay. It's whether you are amenable to service of process by the courts in this state. And when they generally appeared, filed an answer, moved to dismiss, said the forum selection clause applies and we get to enforce it, and they won and moved it to a different federal court that then just kicked it right back because that court was unable to hear the case, they both generally appeared, and it would be a wildly inequitable result to let them pick and choose, take advantage of the Texas courts, and then because we were correct the entire time filing it in Texas state court because we knew that was the only place it could be litigated, we're now punished from moving forward in that proceeding that they had already generally appeared.
What do we do with the argument, though, that a non-suit means everything goes poof, that it's as if nothing ever happened? It's like a you know, when you get a bug in your computer and you have to do a hard reset and all your files are gone.
And that's just not what happened here. They filed a motion to dismiss, and they answered in the case. And so they took those positions. They affirmatively represented to the court, we may invoke the forum selection clause. It applies to these claims. There's no magic eraser that you get to take away the affirmative representations you brought in a motion that you succeeded on, that you got a court in Texas to spend its time reviewing and issuing an order. There is no case they have pointed to that says you get to magically erase those representations and that affirmative litigation that they voluntarily chose to pursue. They could have filed a special appearance in that first action. And then we wouldn't be talking about waiver. Then we'd only be talking about how it went all the way up the chain and they purposefully availed themselves of the state of Texas.
So one other question I've been wanting to ask somebody about personal jurisdiction. Needless to say, personal jurisdiction's changed a lot with Southwest Airlines and everything else. So Worldwide Volkswagen says there's 2 reasons to have minimum contact test: the burdens of litigating in a distant forum. Now, are you litigating in a distant forum?
Our clients, no.
Right. Because they're located in...
Well, the funds themselves, and it's made up of a bunch of investors.
There's Delaware or
Yeah.
New Jersey, right?
Right.
And so you are litigating different, but practically speaking, that for clients like you and cases like we have in this court, that's not a burden anymore. The other one is principles of federalism. And again, you know, we have a global economy, if not at least a national economy. And, you know, if you're going to buy a big share of the Permian Basin, it doesn't sound that much of a federalism problem to say, well, come on down here and we'll work through that. So which of those factors, burden or federalism, says, or is it just the technical rules, we don't have to do it here, sorry.
And all of that counsels to finding personal jurisdiction and purposeful availment in Texas. You have this company who decided to put $500 million into buying Texas oil and gas and running that company with its employees from New York. It's pretty, if not laughable, close to it for them to come in and say it would be a burden for us to appear in court, but it's not a burden for us to own all this gas, profit from this gas, and ship it back to New York. No further questions? Thank you, Your Honors.
Thank you. Mr. Cole? Again, same last question. What is the basis for why we shouldn't either? Is it burden, is it federalism, or is it something new?
Oh, I mean, there's no general jurisdiction because the headquarters isn't here, and there's no specific jurisdiction because the requirement that's been around for decades, requirements have not been satisfied. And we can say interests of federalism and sort of look at that from different perspectives, but yeah, interests of federalism. I mean, Texas courts are, we all think Texas has the power to run the rest of the country, but perhaps other states might have a different view of that. Perhaps we might have a different view if Idaho showed up here to tell us what to do. And that's not an idle formalism. It's a serious question of power, and those rules have been in place for decades. So I get it. When we're not arguing hardship, I mean, there's an override to jurisdiction if those requirements can be met, but it's unfair for some reason,
right.
Those due process factors, but that's not what this case is about. The question of disposition, ordinarily you would remand. I think because the jurisdictional issues here overlap considerably with the ones that were addressed on the merits, the court would be within its rights to examine those and affirm.
Do it all
because
in one big...
there's not a lot of additional, measuring of things that needs to occur. That's already occurred on similar issues, and the court needs to go no further there. What I heard was missing in the sort of dramatic reading from various pleadings that my very well-spoken colleague did just now is an explanation of why there's an inconsistency for purposes of judicial estoppel. The question isn't just, is there some pleading somewhere where the word same appears? There are two precise questions posed here. There's the question of whether it's in the same proceeding, I said the right word that time, and there's the question of whether judicial estoppel, which applies everywhere, not just in personal jurisdiction, whether that representation of fact has something that inconsistent has been made. And remember, it's in a context where, as you point out, Justice Ferris, there was a non-suit. So there's no collateral estoppel effect, no issue preclusion, no claim preclusion. It's that wispy of a statement legally. For that to become the basis of judicial estoppel is a stretch. For this context and for judicial estoppel generally. And the argument that the rules refer in places to amenable to service by the courts of this state is clearly just a general reference to personal jurisdiction with kind of some fancy words in it, but it's not a suggestion that the word proceeding at the beginning of the rule means something other than what the well-established principle of that rule is. On the question about the company spending money in Texas, that kind of high-level summary. Let's not forget that Texas has a requirement, all courts do, but Texas makes it express in its personal jurisdiction test for specific jurisdiction about the operative facts of the case. The operative facts of this case involve a specific sales decision, and that's where this argument breaks down, because the contexts they point to either don't involve those operative facts, or they involve people who have not been shown to be acting as agents or whatever the other legal doctrine may be with respect to the relevant parties they've named. The alter ego claims here are not serious claims. These are independent entities for independent purposes that they know full well existed when they got into this deal, because there's nothing unusual about that structure. And the doctrinal requirements of specific jurisdiction and a connection to operative facts have not been satisfied here. And with that, I think I'll give my remaining minute back to the court.
Thank you, counsel. Court will stand in recess, brief 10-minute recess, and then we'll take the other half.
All rise.
Be seated, please. Court calls Primexx Energy Opportunity Fund versus Primexx Energy Corporation. Who's present for appellant?
Brian Caforio again, Your Honor.
Mr. Caforio, and for appellees?
Caston Mitchell, Your Honor.
David Cole.
You all be splitting time among yourselves, so
Yes, sir.
keep an eye on the clock, because I don't handle that. You may proceed.
Thank you, Mr. Chief Justice, and may it please the court, I'm going to reserve 5 minutes for rebuttal. We're here today because the trial court made two fundamental errors in misconstruing a partnership agreement and granting a pre-discovery summary judgment that violates clearly established Texas law, rewrites the partnership agreement to render numerous provisions wholly superfluous, and interferes with sophisticated parties' freedom to contract. Now, first, the trial court misconstrued the agreed-to terms in the partnership agreement in a manner that is completely incompatible with the actual language in the partnership agreement. And second, the court wrongly found as a matter of law the defendants acted in good faith and dealt fairly with their partners as required by the partnership agreement, even though it was a pre-discovery motion for summary judgment where defendants introduced absolutely no evidence to prove that they satisfied that standard. So for 35 years, the Texas Supreme Court has provided consistent guidance for the ordinary and common meaning of good faith under Texas law when it is not otherwise defined.
But the legislature hadn't always liked that, and they've come in over and over and made it, no, it's narrower and narrower than, I mean, you know, it used to be, if you were a fiduciary, you had to prove that you hurt yourself. And the legislature just had enough of that. And so, I mean, what's unclear about, you know, the parts of 5.9 that says they can make a decision solely on the basis of the interests of the managing general partner desires to consider?
Subject to the agreed duties. And the agreed duties mean our good faith. And that's why I wanted to say what the Texas Supreme Court has said that means. In 1992 in Crim Truck, in 2016 in Gulf Energy, and as recently in 2019 in Janvey, what the Supreme Court said that means is, quote, conduct that is honest in fact, reasonable in light of known facts, and free from willful ignorance. So that's 592 SW 3rd at 129. So you just plug that in to this contract, okay? So you're looking at 5.9 C2, and it says the other partners may decide or determine any matter in its sole and absolute discretion, taking into account solely its interests and those of its affiliates, excluding the partnership and its subsidiaries, subject to being honest in fact, reasonable in light of the known facts, and without willful ignorance. And that is completely consistent with Texas law. It is completely consistent with all of the other terms in this contract, and it does not render anything superfluous. So I'd like to invite the court's attention to two separate provisions in here that I think really crystallize this issue. Okay, so right after 5.9, we have 5.11. Okay, 5.11 is a carve-out to the duty of loyalty for PEC only. And what 5.11 says is, notwithstanding the existence of this agreement, the managing general partner, without having or incurring any obligation, may engage in activities that are competitive with the partnership. That's how you do a carve-out. That's how you write the text. And I would probably agree that these plaintiffs could not have brought a duty of loyalty claim against PEC for competing with the partnership, given this express carve-out in 5.11. I'd then invite you to take a look at 6.7E okay, 6.7E, which says that Blackstone does not incur any liability or obligation for canceling a drag-along transaction. In 6.7E, Blackstone does not incur any liability or obligation for canceling a drag-along transaction. There is no corresponding provision in 6.7A or anywhere else in this agreement that says Blackstone does not incur liability or obligation for carrying out a drag-along transaction. There are 21 different times in this partnership agreement where the parties expressly agreed that a provision applies notwithstanding this agreement or notwithstanding the other provisions in this agreement. 21 separate times they wrote that. They didn't write it in section 6.7A. 5 separate times the parties expressly limited or eliminated other fiduciary duties. And every single time that they did, they said, except the agreed duties.
So let me make sure I've got it. So you're saying we import common law good faith requirements into the contract that are not stated in the contract?
Not quite in those terms. So what I would say is, and this is accepting defendant's argument, they say the way the agreed duties are written is that they can only apply to the minimum that Texas law requires. Now, I would fight that and say, if you're trying to have something reach the minimum, it's sure an odd way to write, it applies to the maximum, and it's sure odd to eliminate all the others, but expressly not eliminate these. So I would say that's a really obtuse way to put that in an agreement. But let's accept it. Let's look at what the minimum is. And the minimum, you can go to Crim Truck, their own best case, and what that court said in 1992 is a fiduciary duty encompasses, this is the quote, at the very minimum, a duty of good faith and fair dealing. The duty of good faith and fair dealing requires the parties to deal fairly with one another. So that's the minimum duty. That's the absolute minimum. We think it's above the minimum, but that's the minimum. There is that duty to deal fairly. And then the Supreme Court expanded on that in Gulf Energy. It expanded on that in Janvey and says, here's what good faith means as a matter of law when it's undefined. It means honest in fact, reasonable in light of the known facts, and without willful ignorance.
So I've got a question just on how you prove a lack of good faith. If you're correct that it's generally going to require discovery and investigation into a party's subjective state of mind, does that mean that you're never going to be able to resolve a good faith issue as a matter of law?
No, we would not take that position. We would say that there are many circumstances where you could have evidence that what you did was reasonable in light of the circumstances. We don't have that here. What we have here in the record, and it's in there multiple different times, but one example is CR 1479. It was Exhibit 7 to PEOF's opposition to the motion for summary judgment, and it has a valuation of this Texas oil and gas company of between $1.9 to $2.5 billion from 1 month before this transaction. That's the evidence in the record for what this is worth. You have the defendant Doyle, who said, I know this is a bad deal. I've been told by Blackstone executives we're divesting from oil and gas, and so we're just taking any deal we can get. In that circumstance, yeah, they can't win on summary judgment. So, and a trier of...
So let's say Blackstone was wanting to, not have any fossil fuels dirtying their skirts. And so that's the interest of the general partner, not to have any fossil fuels and getting heat from everybody from that. And that may be bad for your clients and for the other investors. But why is that not the basis, exactly what this says, that they can decide solely on the basis of their own interests?
Because it's not, quote, reasonable in light of known facts. If they know the company is worth $2.5 billion and they sell it for $788 million because that's where their spot in the waterfall ran out, that's not reasonable in light of known
But
facts.
it doesn't say we're going to maximize profits for anybody. It says just the opposite of that. It says solely on the basis of their own interests. It's not limited to what kind of interest.
But it is limited by the agreed duties, and the agreed duties are
So there's not a list of agreed duties in here anywhere.
Yes, there are.
Where is the paragraph that addresses agreed duties?
Agreed duties is 5.9, and it says 5.9A, and it says each partner and the managing general partner shall, to the fullest extent required by Texas law, owe to the partnerships and its partners the duties of good faith and fair dealing. And they never limit that. They never reduce that. And when they say you can act subject to your interest, it says subject to this agreed duty that they negotiated to include, and that 5 separate times they agreed not to limit. And so we look at what does that mean in practice? It means you have to deal fairly. And so there's no price floor. We're not saying it had to be X price or Y price. And if there were 10 valuations, Justice Ferris, that were, $750 to $800 million, and they could point to that, they'd maybe be able to come in and say, this is reasonable as a matter of law. The known facts are that it's worth $750 to $800 million. We sold it for $788. Have a good day. Sorry you got poured out. And we'd have a tough case. But that's not the case. The case is the only evidence in the record is that this company was worth $1.9 to $2.5 billion. They knew that it was worth $1.9 to $2.5 billion, and they still sold it for $788 million over a weekend when the head of the company said, I know this is a bad deal, but they wanted to divest from fossil fuels to try to get a big investment from sovereign wealth funds who didn't want to be associated with fossil fuels. That is not reasonable in light of known facts. Now, they can certainly come into a trier of fact, and they can try to make that argument. They have great lawyers, and they can stand up and argue why, in the face of that undisputed valuation, this actually was reasonable in light of known facts. Maybe there were no other offers. Maybe there was some big problem with the company that it was going under, and they needed to go out as quickly as they could. They'll have the opportunity to make that argument. They can still win this case. But what they didn't do on summary judgment before there was any discovery, and in the face of this unrebutted evidence in the record about the known valuation of the company, about the known admission that it was a bad deal, they did not already establish as a matter of law that their conduct in that fire sale was reasonable in light of known facts. That is what they did not establish as a matter of law. And so everybody agrees. At the business court, he agreed in the motion for reconsideration, oh yes, they had to deal fairly. Oh yes, they had to perform this correctly. As long as there's any standard at all, when they don't introduce evidence that they met that standard, however low that bar is, they didn't put in any evidence, they couldn't succeed on their motion. And so here, they try to misconstrue the record in their appellate brief saying, oh no, discovery was actually almost completed. It wasn't.
So this is a drag-along right in 6-7. Am I correct that there's nothing that's not conditioned on agreed duties?
The agreed duties are not mentioned in 6.7a. So there's 21 times where they put something.
But what is mentioned is that you all have to agree if they decide they're going to sell.
Correct. It's a negative
As long as they
right.
waited 2 years, as long as it's arm's length, et cetera.
Yeah, 6.7a is a negative right. It imposes an obligation on the other limited partners to agree to a drag-along transaction. And so the only actual right under 6.7a, if you read the text, is theoretically to bring a breach of contract against a limited partner who didn't vote for it, which the only way you could succeed on a breach of contract claim would be to establish that you complied with your obligations in the contract, including the agreed duties of acting in good faith. And so 21 different times in this agreement, when they made something, they didn't want it to be subject to the agreed duties or something else, they say, notwithstanding the agreement, notwithstanding the provisions. That's noticeably absent from 6.7a. And we would subject that when you don't limit it there, 5.9 applies to the contract as a whole. It is an agreed duty to deal fairly, to act in good faith, that is applicable throughout the entire contract unless there's some specific carve-out. And there is no specific carve-out here, and in fact, to the contrary, they do not limit it at any point. I'll
Thank you,
reserve the rest
Mr.
for rebuttal.
Caforio. Ms. Mitchell?
Good afternoon, Mr. Chief Justice. May it please the court, Kasdan Mitchell. I'm going to argue the summary judgment issues, and my co-counsel, Mr. Cole, is going to deal with the balance of the issues in this appeal, principally personal jurisdiction in 91A. In exchange for hundreds of millions of dollars in much-needed capital from BPP, the partnership in this case expressly agreed that after certain conditions are met, BPP could exercise a drag-along right. That right, by its nature, involves a transaction that is against the interests or the wishes of the other partners, or else they wouldn't need to be dragged along. Appellants do not contest that BPP satisfied the conditions of 6.7, that 2 years had passed since the effective date, that the sale was to a third party, that it was an arm's length transaction, and that it constituted an exit event. Instead, they ask this court to invalidate the transaction based on statutory duties. But consistent with Texas's longstanding policy favoring freedom of contract, the Texas Business Organizations Code imposes only minimal duties on partnerships. And even then, parties can largely contract around them. That's exactly what the sophisticated parties did here. Indeed, as the Chief Justice mentioned earlier, the parties expressly agreed that the managing partner could act, quote, in its sole and absolute discretion, taking into account solely its interests, end quote.
Subject to Clause A.
Correct, but I don't think you can read the agreed duties to mean the exact opposite of what is provided in the first part of that sentence.
So what does it mean?
I'm sorry, what did you say?
So what
Your Honor?
does it mean?
His
So I-
argument is when you said to the maximum provided by law, and you say that means the minimum provided by law, so actually, sometimes you can say the opposite of what you mean, right?
I don't think that's the right way to read 5.9. It's really, if you look at the intersection of subsection A and subsection B, what the parties were doing is establishing a bare minimum. So subsection A says each partner in the managing general partner shall, to the fullest extent required by Texas law, that's basically saying, we're going to do everything that's required and nothing more. And then you see different language used in 5.B, which says 5.9B, to the fullest extent permitted by law. And so that's different language. And in there, they talk about how the parties shall not owe any fiduciary or similar duty whatsoever to the partnership. So if you look at those two provisions together, it's basically saying we're going to do what Texas law requires and no more. And to answer your question, Justice Field, about how these provisions intersect with the statute, if I could just walk through the way I think that language intersects. So in 5.9A, the provision provides that the duty it's to the fullest extent required by Texas law with respect to the duty of good faith. So then you look to the Texas Business Organizations Code. And the good faith provision in 152.2b says that partnerships cannot, and this is in B4, eliminate the obligation of good faith except that partners by agreement may determine the standards by which the performance of the obligation is to be measured if the standards are not manifestly unreasonable. Here, the parties provided the standards for exercising the drag-along right. It had to be 2 years later, third party, arm's length. It couldn't be self-dealing. I mean, that's what those requirements. And it had to be an exit event. And so long.
Let me ask you there, manifestly unreasonable, is that a fact question for trier of fact, or how does that work?
The most recent Texas appellate court case that we could find, so there aren't any Texas cases defining that. I think the inclusion of manifest makes it not necessarily a fact question. It's, is it obvious on its face?
If it was just unreasonable, that'd be a fact question, but if it's manifestly unreasonable, then.
There may be some instances in which just unreasonable wouldn't, but certainly the addition of manifest, which just the plain dictionary definition says obvious to the senses, wouldn't require fact development. Nor have they argued that a drag-along provision itself is manifestly unreasonable, and that would be inconsistent with law in this state, across the country. Delaware courts have recognized that they're common provisions. We found a CLE from Texas M&A practitioners talking about drag-along provisions. They're in fact in model forms, so there is nothing manifestly unreasonable about a drag-along right.
I guess what confuses me is if the standard of the drag-along provision is you have to do A, B, and C, then why include the language about the good faith duty or the agreed duties?
So 5.9 applies to the contract entirely. So what that's saying is, you're subject to the minimum required by state law with respect to good faith. And then you go look at the statute. What does the statute say? And it says the parties can eliminate good faith unless they otherwise provide standards. And then in the case here, we're talking about the drag-along provision, and the parties plainly provided the standards that were governed. So if 5.9 was a part of 6.7, it may be a different question, but that's a general provision that governs the parties generally. It doesn't speak specifically to the drag-along provision. And the drag-along provision, to the Chief Justice question, doesn't speak specifically to the agreed duties either, so I think you have to read them in concert. And one interesting thing about the drag-along right, as opposed to the other provisions that the other side is emphasizing, is it's a bespoke provision to Blackstone. So this was something specifically negotiated with the funds, that if they're going to take this influx of hundreds of millions of dollars of cash, yes, Blackstone had to wait 2 years, had to be to a third party, arm's length, and so forth, but they permitted Blackstone specifically to exercise this right, and that's the party's bargain that the business court enforced. And I don't think you can read agreed duties and kind of the minimum requirements of Texas law to undo the very preceding clause that allows the parties to act in their sole interest. And just to put a finer point on that, it's not just in their sole interest, it's with absolute discretion, taking into account solely their interests. So that's exactly what the parties bargained for, in addition for the much-needed influx of cash. A few other points I wanted to raise in response to the earlier argument. For the other provisions that the other side spoke about, first of all, those weren't really a focus of their briefing, but I take the court can look at the agreement in its entirety. In 6.7e, where it talks about canceling a drag-along provision and having no liability or obligation, with respect to canceling, the parties could set their own limits. With respect to the exercise of the drag-along right, the parties could set their own limits, and the limits that they set were provisions requiring arm's length, third party, and the passage of time. In addition, the other side relies heavily on the Gulf Energy case. That was a case involving the Texas Railroad Commission and a statute, and the Texas Supreme Court said in that case that the legislature can make good faith, can impose measurable, objective criteria to good faith. And that's exactly what the standard to be measured language in the TBOC allowed the parties to do here.
So has any Texas court construed 152.002?
Not that I'm aware of with respect to the issues here.
So that's of course what makes us nervous. We have to be the first one. And we can't, surely it got to mean something. You can eliminate the duty of care, but you can't eliminate the duty of care, but you can determine the standards. So to make that mean anything, it can't mean you can eliminate the duty of care, but the standard you can adopt is you don't owe a duty of due care. You couldn't do that.
Correct, Your Honor. And you couldn't say, or the standard measured is standardless, something like that.
And the standards for good faith is you can act in bad faith. It couldn't do that.
Correct.
So what kind of standards does that mean? I mean, I guess you could say it's duty of care, it must be clear and convincing, or, beyond a reasonable doubt, or something like that.
Is it, just to follow on with that, is it the fact that this can be done in an arm's length transaction, is that like what kind of salvages some measure of good faith? Is that it?
It does. What it says is the parties can establish their own standards. And here, I think to Justice Ferris, your point, the standard here is that it has to be arm's length. It also has to be a third party. And they also built in a buffer of time. I'm not sure that if you eliminated one of those, that we'd all of a sudden have a good faith problem.
So if the sale had been for $1, so long as it's arm's length and within the relevant time frame, that would be enough?
It's hard to imagine a third-party arm's length transaction that would result in that, but if that's what the market found that it was worth, then that's what the parties agreed, then yes, I do think that
Well,
would
you'd
satisfy
be-
that.
The third party would be a fool not to take, take it all for a dollar. So isn't that close to, I mean, that's what they say happened here. You know, they found a third party who was willing to take a bird nest on the ground. And so that can't be the standard because it's effectively the same thing as saying there's no standard.
Well, it's far from the facts here, where the transaction was $788 million. But
That's true. That's not a bird nest.
I take the hypothetical. And in this case, when you have a provision that allows one partner to exercise their sole and absolute discretion, I think you run the risk that there may be some transaction that doesn't satisfy some reasonable term requirement. And you know, over and over, the other side talks about how, well, if it was, you know, 750 to 800, we'd have a question. I mean, at the end of the day, what they're seeking to write into this provision is a reasonable price requirement that they didn't put.
Well,
And
their main argument is because a month before you said it was a bad deal, or 2 days before you said it was a bad deal, whatever it was.
there are some allegations that, you know, we would dispute with respect to that, but they're not material to the issue here because there isn't, I mean, the issues that they're seeking discovery with, and I think that comment would go to, is only if the court concludes that the requirements of being honest in fact, reasonable in light of the circumstances, without willful ignorance actually apply. And the parties didn't, you know, they have a contract that doesn't import those implied common law duties into their decision. So those issues and the discovery they're seeking are two legally irrelevant issues. If they want a discovery on whether 2 years had actually passed or whether the transaction was in fact arm's length, this would be a different case. The discovery they're seeking, which by the way, they didn't even comply with the Texas rules of putting in an affidavit saying what discovery they needed under 252. But even if they had complied, the discovery they're seeking has nothing to do with the standards that the parties agreed would govern when a party could exercise a drag-along right. And just one other point before I turn it over to my colleague, unless the court has any other questions, is the fair market value requirement is all over this contract, as is a unanimous consent requirement. There is no pricing minimum, no reasonable pricing term anywhere to be found in 6.7, and the freedom of contract in Texas is at its zenith between sophisticated parties, and they agreed to allow Blackstone to exercise this drag-along right, subject to criteria that Blackstone followed to a T. So for those reasons, we'd ask the court to affirm the summary judgment.
Thank you, Ms. Mitchell. Mr. Cole?
May it please the court, I'm here in a distinct proceeding, I think. But notwithstanding that, I want to talk about one of the 21 examples where notwithstanding is used. It's section 13.9, and that's what leads into the exclusion of liability for the Blackstone entities and Mr. Doyle. That provision is very clear, and there are two counter-arguments made against it that I just wanted to air out in my time today. There's an argument that, well, there's some question about what kind of third-party beneficiary relationship that creates that's moot. PEC is a party to the agreement. They appeared, they joined the request for dismissal. There's no dispute about that. And so that's, I think, an interesting sideline that the court need not address. The other argument is that this somehow interferes with section 152.002 about partner duties, some of the topics that we were just discussing, but the people that are the beneficiaries of this provision are not partners in the first place, and in fact, they have an obligation to do what they're told. And so once the decision has been made to go forward with this drag-along sale, PEC and the various individuals are then obligated to do that, which is why you have this kind of provision, because they're complying with what they're supposed to do under the terms of the agreements and not engaging in independent tortious activity. So the section 13.9 was correctly applied as to those entities and Mr. Doyle, and the counter-arguments, I think, are not well taken. A note on control, alter ego, jurisdiction, and then I'll surrender my time. But the claim has been made in the argument in the previous discussion and just now about sort of that they took the money and it went down and it went back up. There's a lot of moving around of money. But the actual allegations, and these are gone through in our briefing, but it's worth just focusing on those for a second about what control allegations are actually made to support that claim. For one thing, there's a lot of group pleading here that's a no-no in this setting, but just let's move on from that. You've got three of the allegations. There are let me count up the right number here. There are, I think, just about 10 allegations that relate to control. 3 of them describe truisms, that BPP was the majority shareholder, that it appointed certain directors, and that it exercised drag-along rights. So what? That's what the contract says. That doesn't create control issues, alter ego issues, or anything unusual or untoward. There are 2 other claims using different language than what we heard today, but the same sort of flourish on the previous allegations, that Blackstone was a matrix in its operations, and that there is complete control as opposed to just control, kind of like the manifestly unreasonable thing. But those are legal conclusions. Those are not arguments about fact that would give rise to claims. And then there are, again, a number of, so what, non-material allegations about the use of Blackstone.com email addresses, using the same mailing address with the SEC, and some interplay of people, trusted employees and trusted positions in these different entities, none of which is untoward, all of which is common practice. And the final argument, the alter ego argument, there's nothing that suggests there was some confusion about which entity somebody was dealing with. These documents are exhaustive in their detail about who does what, and there's no claim that someone thought it was Blackstone number 1, 2, 3 as opposed to Blackstone number 4, 5, 6, or something like that. The balance of the issues that were addressed by the business court correctly address personal jurisdiction that was discussed before. And again, the 2 problems there are a number of problems, but the problems are the operative facts problem, the proof of agency problem, and for Mr. Acconcia, the fiduciary shield problem, because they're all derivative claims, which takes us full circle to what the exclusion of liability clause is clearly intended to address, which is to get these individuals out of the firing line on these claims in the first place. With that, I'll yield my time.
Thank you, Mr. Cole. Mr. Caforio.
Thank you, Your Honors. I want to start, just to clarify, my colleague argued that we don't seek to enforce any contractual duties, only statutory duties. That's not correct. We seek to enforce the contract as written that includes the agreed duties of good faith and fair dealing that the parties expressly declined to ever limit or eliminate, even though they did it to every other fiduciary duty. We agree that the freedom to contract is sacred in Texas. We agree that you need to enforce the contract as written, and there is only one side that is promoting the terms of a contract that are consistent throughout, that doesn't render a single provision superfluous, but it does if you accept defendant's argument. And so look at 6.7e. Counsel got up and said, what's so important about 6.7a is that it's a bespoke provision only about Blackstone, and that means we really need to look at it. So 6.7e. 6.7e is only about Blackstone, and it says that Blackstone does not have any liability or obligations if it cancels a drag-along transaction. That provision would be wholly and completely superfluous if you accepted their argument that the agreed duties means nothing, that subject to the agreed duties means nothing, and that they could always act solely in their own interest and only at their discretion. Then you wouldn't need to put in a provision limiting their liability for canceling a transaction. They always had the right to cancel a transaction. That's solely in their interest. It's unconstrained by the agreed duties. But these sophisticated parties who were lawyered up the wazoo put in 6.7e and said, we need to protect Blackstone if they pull out of a drag-along transaction. There is nothing in there that says their liability is limited or that they don't have obligations for executing a drag-along transaction. So we would submit that the language in this contract, the actual terms that the parties agreed to in this contract, matter. So when 21 separate times the parties wrote, notwithstanding the agreement or notwithstanding the provisions of the agreement, so that they could provide a carve-out of some right or obligation unconstrained from the rest of the agreement, and they didn't put it in 6.7a, that matters. we submit that when 5 separate times the parties limited or reduced every other fiduciary duty, and they did not do so to the agreed duties of good faith and fair dealing, that matters.
What do we do with the argument that the time frame, the arm's length transaction, that those are essentially defining good faith and that the parties are allowed to do that?
I would say that's inconsistent with everything else in the contract. And so
Is there any case, though, that...
As both sides have said, the case law on this is sparse.
Sparse, yeah.
And so you have language that says you can set the standards.
Sure.
And so I think 5.11 is really the best comparison here when you see the language that these parties demonstrated they knew what to do. So in 5.11, when they wanted to give a carve-out to the duty of loyalty, which that same statutory scheme says you may put a carve-out in there, they said it expressly. And they say there is no obligation or no liability if you compete with the partnership. So they demonstrated the clear ability to put a carve-out, remove liability or obligations when that's what they wanted to do. And they did it those 21 other times. They did it when they didn't reduce the agreed duties at any point in the agreement. And so we submit that that language choice, that agreement matters when they choose not to put that in 6.7a. If they had said in that provision, A, B, and C, 2 years, arm's length, and if you meet all those, there is no obligation or no liability, as they put in 6.7e, we'd have a different argument. But that's not the language in this contract. The language in this contract is that they have to act in good faith and fair dealing. And what that means at a minimum under Texas law is that it was reasonable in light of the known facts. And when the only known facts in the record are that this company was worth $2.5 billion and they gave a $1.8 billion haircut so they could get out of Texas as quick as possible, there is a fact question as to whether they dealt fairly with their partners as they were contractually required to do. Thank you.
Thank you. Case will be submitted, and counsel will be discharged, and we'll take a brief break before we have our last argument.
All rise. Be seated, please.
Welcome to the survivors. Our last case today is Shannon Medical Center versus Sickles and Cole. Who's present for appellant?
David Walsh.
And for, I'm sorry. Are you all splitting time, or? No, that's all right, please, but please, you would take an announcement, so you can get credit for it. Thank you, and,
It's Kyle
Appellees.
Dreyer on behalf of,
all right,
and along with me is Josh Flippin and Matt Keita. We are not splitting time unless, of course, the
Good.
court asks something that I don't have an answer.
right. I doubt that. You may proceed.
May it please the court, David Walsh with Anna Romano for Shannon Medical Center. I was in the hallway during the other cases, and I just want to say, you've been through a lot today, so if you would, I would rather you ask me whatever you want to know than me give prepared
Whatever we
remarks.
have left in us.
Correct. I have some prepared things to say, but I'd rather just answer your questions. So, as I was thinking about this case in the hallway, this is the case we're saying is a healthcare liability claim. And one of the reasons we're saying it's a healthcare liability claim is it's a safety claim that has a substantive nexus to healthcare. And I look at the Ross factors and I say, what are we trying to protect there? And we're looking at, is the patient potentially in harm's way? And if you look at the facts of this case, the location, radiology department, where the patients might be, you have claims by people that are in the radiology department where patients might be, and you have a device that's used in treating patients in the radiology department, the X-ray machine or CT scanner. And if one of them is emitting more radiation than it should be, that would seem to put patients in danger. And under the Ross factors, however we want to slice and dice them, that's the very purpose of Ross, of looking, is this a place where patients can be and patients could be harmed by what they're saying? And that, I think, is this case. And so,
But is that asking us to assume too much? I mean, I'm not an expert on radiology doses, but I assume that there might be a difference between a patient coming in for a one-time X-ray who's got a broken arm, that's the only X-ray they have in their life, versus, standards that might be more directed towards protecting, people who are there every day.
sure, except for,
Sure.
we don't know the dose leak, if it's a leak. So I view this
Yeah.
as two ways, one of which they talk about that machines are emitting more radiation than they should, which I equate to a leak, which would overexpose the patients and make them susceptible to cancer on top of the one X-ray that they got. Because sure, maybe one X-ray isn't enough to cause cancer, but maybe the machine is leaking enough to cause that problem. Or that's increasing their lifetime risk of cancer, because if you have enough X-rays, there is a lifetime risk of cancer, so the patient is back in harm's way. So I don't think it's really asking to assume too much based on what they've alleged about overexposure to radiation, because the patient is in the same harm's way as Sickles and Cole.
Does it affect the Ross factors at all that the statute they've actually sued under for radiation exposure does not, I think it excludes claims by patients?
It excludes treatment is what it's excluding. Basically, the statute's saying, we're not practicing medicine. If a doctor wants to prescribe dose X, we as the statutory, I think that's in the regulations, but we as the radiation board are not quibbling with what the doctor and his standard of practice view. But this is where it gets back to, it's not a treatment or lack of treatment standard. We're talking about the safety standard. And if it's causing overexposure to radiation, that's the problem with why it's related to, has this substantial nexus to healthcare, because in going to get the treatment that they're not controlling, they're getting overexposed by what they're alleging the hospital did or didn't do. And that's why it's the substantial nexus, and why I think the Ross factors come out this way regardless of whether patient treatment is involved. And indeed, we know from, sorry, I'm blanking on the case name, give me just a second. Coming Attractions, they made it very clear that the statute was broadened from patient to claimant to make it very clear that it doesn't have to be the patient that's involved in the treatment. And so when we get to what they say about the regulatory statute is they say things like, it applies to the oil field, it applies to other places that might have it. But when you apply it to a hospital, who are you looking to protect? You're looking to protect the workers and the people in the building getting treatment. And so if there's a radiation leak there, it exposes the patients just as much as it exposes the workers. And the second thing I'd say about that is the next part of coming attractions is about what happened, right? That's the Ebola case. And so they let Ebola out of the building, expose the business in Ohio, and that's the same thing that's happening here is you're letting radiation go where it shouldn't go, even if it's just in the building, you're letting it out. And that is the very virtue of, or the very nature of healthcare, like letting Ebola out of the building. So,
On the issue, if we could look at the employment question, are the Limestone and Stevenson cases in conflict? And if so, how do we reconcile that?
I don't think so. And I'll start with one particular reason. The Stevenson waste management case, right, is really, it's a staff leasing case. This isn't alleged to be staff leasing.
Yeah, it's a totally different fact, but.
Correct. And while I think that there are some interesting things in Stevenson that you might look at and say, well, we look at the facts on the ground. Well, you're looking at who's got control, right? And what is the manner and means being controlled? And if you look at their affidavits, they don't say, I was an employee of the hospital. They don't say, I was controlled by the hospital. They have this other little dance around stuff of, I received some training from the hospital. All doctors receive some training from the hospital, right? They have to know how to use the machines.
Yeah, but the machines are a big piece, right? And then there's also the scheduling.
Except for, it's no different than how you do an OR schedule for the operating room, right? The surgeon isn't under the control of the hospital because they say, show up at this time to do your procedure. Same thing with scheduling for the department, right? We've got to get these patients in at a particular time, but it doesn't control the two things that I think are what a radiologist are doing. They're reading films, right? How does that control how they read the films? Because scheduling doesn't even tell them the order that they read the films in. They read films. Then the next thing is they're doing interventional radiology procedures. Well, they're not telling them how to do the interventional radiology procedures if you take their allegations. They're just, or I'm sorry, not their allegations, their affidavits. There's nothing in there about the manner and means by which they were exposed to radiation. And that's when we look at manner and means from Stevenson and the other case whose name is escaping me that you mentioned.
Oh, Limestone.
Yeah, Limestone, is you're looking at the manner and means of what caused the injury. And so what do they say about manner and means of injury causation? There's nothing in those affidavits. It's all a bunch of vagaries of things that you do between a doctor and the hospital where they have privileges, where they have to collaborate to some extent so that they can run a medical facility. And so that Shannon Clinic and its doctor employees are coordinating or working with Shannon Medical Center so that the health system can run as a whole. That's not surprising. That happens in every medical system that there is. There is got to be coordination of care so that we have people doing what they need to be doing. But it doesn't control the manner and means by which it's done. So it schedules, we can go to OR6 today because OR6 is available for your procedure at this date. But you can't go tomorrow because we already booked that for somebody else. Same thing with radiology workflow. It's the flow of the radiology department. We've got to get all the cases through, all the people seen, all the films read, all the interventional radiology procedures done. It's all just a coordination of care, but it's not the manner and means by which they do their job. And that's the mental part of being a doctor and thinking about the case, or the physical part with their hands of actually doing the interventional radiology procedure. And there's nothing in the affidavits about controlling the manner and means by which they do their work. And that's why I don't think it meets the employment thing, particularly when the record has their employment contracts, which even in their affidavits, they admit we have signed employment contracts with Shannon Clinic. And so how with the vagaries of things that aren't manner and means by which they're actually doing their job as a radiologist, how does that trump the employment contracts, which very clearly is an employment contract with Shannon Clinic? And if we look at another factor, payment, the only evidence of payment is in the contracts, and that's them getting those WRVUs, which is a medical mumbo jumbo for some work productivity thing of how much we make and how much you'll get paid out of that. But that's how they're getting paid. but by Shannon Clinic, nothing by Shannon Medical Center. And so while the instrument, you could think the instrumentality, oh, that's the x-ray machine, except for it's not. The instrumentality is actually the doctor looking at the film and saying, you've got this disease process from that, and that's not controlled at all by Shannon Medical Center, at least according to the affidavits. And so vague things like, we got training and guidance, we talked to the chief medical officer or the chief executive officer, none of that discusses how that's manner and means of doing their jobs, and particularly as they're exposed or overexposed to radiation. And that's why I think that that's just the problem with this case, for that perspective of employment just doesn't seem to fit the bill with what they're doing. While they've alleged it as a non-subscriber case, it doesn't seem like it's a non-subscriber case when you have their own affidavits, don't say anything about controlling the manner and means, and you have these employment contracts. So how is it within the exception? And then when we go back to, well, okay, so what does that mean for you, David? And I would say, well, that means that they can't artfully plead around Chapter 74 then, which is what we look at it as, is this is just a manner of artful pleading to get around the healthcare laws. And that's our trouble with this case, is because they work for somebody else, Shannon Clinic. How are they working for our employees under our control of the manner and means of their work? And if they're not, then they're just using this allegation of of the non-subscriber thing to get around the statute that we were entitled to a report for. And since they don't have a report, they just have medical records, and they don't even defend that the medical records in this court, they don't defend that the medical records constitute a report, that requires dismissal. Keep in mind, if there was ever doubt 74-353 existed at the time of this claim, they could have said within 30 days of us answering, hey, this isn't a healthcare, Charcoal ruled that this isn't a healthcare liability claim, and we could have had a debate about that before the expert report requirement expired, but now it's expired and you can't go back. And even under 353, if the trial court gets it wrong and says it is or isn't, that can be appealed. But more importantly, the expert report requirement doesn't expire until after that determination has been made. And if it's determined, then they get 90 days to get an expert report. So they had an out that they could have used but didn't in this case. And so with it not being employees of the hospital and with this substantial nexus to healthcare, I look at this as an expert report case that they didn't have an expert report on.
Does that mean the lion's share of workplace injury claims by doctors who work in hospitals are going to come under Chapter 74?
Again, I think it would depend on employment question, and then I think it would depend on what their workplace claim is, right? So I'm just going to assume that they're not employees for now, but is it a slip and fall in the hallway? Is it the patient went crazy and beat me up in the hospital and you should have had him restrained? There could be varying levels of what it is. So I think to not answer your question appropriately, I think the answer is it depends. Is there a substantial nexus under the Ross factors or not?
Well, it's just you're always trying to think in our shoes, you know, if we go this direction, what happens in the next case, and the next case, the next case? And that's a ripple effect, as I was listening to you, that I could see happening, is that we, in some ways, make
Yes.
super incredibly hard workers' compensation for doctors.
Except for doctors generally don't, well, I mean, generally, doctors don't work for hospitals, and we talk about the corporate practice of medicine doctrine, but hospitals are really earnest about trying not to do that. And so they set up these separate things like Shannon Clinic, which is its own corporate entity. Even if it has the same executive officer or whatever, it still follows its same structure, and they've done nothing to try to pierce the veil of Shannon Clinic to say that it's Shannon Medical Center. But even if it was, I mean, they're brother-sister corporations that probably would go back to the health system if you're piercing anything. But they've not even made that allegation. So that's, to me, the answer to this is most doctor claims are never going to make it here because they're not employees of the hospital. Because it's late in the afternoon, unless you have more questions.
There's no shame in waiting a minute and a half.
Okay, now I'm going to take no shame and sit down.
Mr. Dyer.
Thank you, Your Honor. May it please the court. I'm going to address this. While there are a number of instances where there is a waiver of arguments, both at the trial court and within this court. I'm not going to address those because I think the heart of this case is in the substantive issues that have already been discussed. And it's for this court to decide those substantive issues for the benefit of doctors and others in hospitals. There are two real issues, and they are intertwined here. The first issue is this is not a healthcare liability claim because these doctors were employees of the hospital doing the work, and the work that they were doing by statute and by administrative regulations was in the power and the control of Shannon Medical Center. That's what 289, 227, and 289, 231 says. It says that it's the licensee here, and there's no contest that these are the licensees, these are the registrants for the use of the equipment in the hospital that emit radiation. It's more than x-rays, it's fluoroscopies, it's a whole host of different things that are in this record. And it is the responsibility of the hospital to control the radiology department and the machinery that's in there. They are the ones that are obligated by Texas law to make sure that that equipment is well taken care of, that they monitor the exposure of the workers, not patients. And in fact, 281, 231 specifically says, not what counsel says, but if you look at the language of that particular provision in 289, 231, it specifically says, not 231, 227, hold on a second. It specifically says that it excludes exposure to patients who are being cared for or treated. Why is that? Because by statute and by administrative regulations, the rules are there to protect workers, not patients, because it's the cumulative dose. That's what the administrative regulation says. It's the cumulative dose that affects those workers. That's what they say. So if you think about it in the context, we submitted affidavits saying we worked full-time at the Shannon Medical Center Radiology Department. We got paid based upon the number of people that we treated there or the number of activities that we did, whether or not a patient is present. Patients are not, and there's no evidence that they can offer that patients are always present in the X-ray room. They're not, because some of the X-ray departments are looking at tissue where patients are not present. So the administrator said, let's make sure that we protect workers, not just in the health field, but in the oil and gas field, in the nuclear industry, the veterinary industry, at colleges and universities like the University of Texas. And we're going to place responsibility for that monitoring, and we're going to place responsibility for making sure that workers are not overexposed. We're going to place that responsibility on the registrant, and the registrant here is none other than Shannon Medical Center. So they had control over the very activities that were being done by these doctors in the radiology department. And the law imposes upon them, and they can't abdicate that responsibility to the doctors. It's their responsibility to protect their workers. And let me just say this, and I want the court to understand. I think you have to read all the statutes together to make sense. And we know that in Texas, we should not ever read a statute in a way that provides an unjust or unreasonable result. That's exactly what they want to have happen here. And let me give you the reason. A lab technician works in the radiology department and is directly employed, because they can employ lab technicians. By rule, they don't employ doctors. Why? Because they don't want to be responsible for the independent judgment of the medical doctor and under a respondent superior theory. That's what they say, okay? So, but they can employ lab technicians. the lab technician gets exposed working in the radiology department to an excessive amount of radiation, and the lab technician does not have a health care liability claim, but the doctor has a health care liability claim. Is that just? Is that reasonable? Or is that absurd? And the answer, in my view, is it's not just, it's not reasonable, it's arbitrary. It's arbitrary. Why would a lab technician, the responsibility is to protect not just the lab technician, but anybody working in, by definition, under the administrative codes, anybody working in and around radiation emanating equipment, and you have the responsibility to monitor, you have the responsibility to provide protective equipment to your people working there. Not only that, but you have the responsibility to train them, you have the responsibility to post notices for workers, not patients. It's all delineated in 289231 and 289227. There's a host of responsibilities placed upon Shannon Medical Center because they're using ionizing radiation. They have the responsibility to do that.
On the point about workers and the employment issue, I wanted to pose the same question I asked your opposing counsel.
Yes?
Are the standards in Limestone and Stevenson different, and does it matter which one we follow?
You know, when I look at that, I get, I got to tell you,
Yeah.
I'm not an appellate lawyer by training, but, and sometimes I would look at it. When I was in law school, I remember there was a professor that asked a question, and one of the students was there, and he didn't know the answer to the question. He whipped out his wallet, and he says, "Kirk to Spock, beam me up." Okay, and I'm not in one of those moments right now where I felt like I need to be beamed up.
Sure.
Okay, but I will say that I think a couple of the cases that they did cite on this issue of the independent contractor are instructive, okay?
Sure.
First, they use this, I think it's a case called Farlow, right? They say, well, the contract's a control, but Farlow actually says, no, you still need to look, not just at the language of the contract, but I think you need to look at who is exercising control, and it's not what the doctors here were doing, it's what the hospital was doing when you're looking at control. And then when you go to the next case that they cite, which is called Redinger, it's not in a medical liability context, but when you look at Redinger, Redinger was a case where there was a general contractor and two subcontractors. And the owner of the property, the general contractor was an independent contractor and the subcontractor was an independent contractor. Well, the owner of the property said, I'm not controlling the means and manner of what they're doing, but the court said, well, wait a minute. You stepped out that morning and you told your general contractor to move the pile of dirt. That's what you told them to do, and to move that pile of dirt now. So that owner took control over that, and guess what? The other independent contractor was hit by the general contractor. Well, here we need to look at who has control. Who has control over what we are alleging here? And the entity that has control by statute, by administrative regulation, the entity has control and is obligated to follow the monitoring procedures, the protective equipment procedures, the notice procedures, and all of that is SMC. And so they have control over that. So to that extent, do they have control over whether the doctor reads the x-ray correctly? Well, no, but that's not the allegation here. The allegation is these doctors were hurt by what SMC was empowered to control and by statute had to control, and they can't abdicate it. Let me also say one other thing about the sort of the unjustness of it, and that is, why is it that an oil field worker working for a non-subscriber who the obligations for exposure to the oil field worker are identical to the limits of exposure for these doctors and the lab technicians and others? Why is it that a doctor who's working in a hospital simply because they're working in a hospital where patients may be present is going to be burdened by the procedural requirements of the Healthcare Liability Act and the damage limitations of the Healthcare Liability Act when the oil field worker, the nuclear worker, the worker in the veterinary, the workers over here at the University of Texas doing research, anywhere else there may be radiation in the state of Texas, isn't burdened by either one. Is that just?
Well, since we're talking about what's just, talk about the coming attractions case. I mean, that's one.
Yeah, and here's the difference, Your Honor, and I would appreciate, and I do appreciate you, and I was going to go straight there, but here's the deal. The coming attractions case did not involve an administrative code specific to radiation. Instead, it was a virus. And as we all know, viruses, and what was acknowledged by the coming attractions case is the virus are spread or can be spread to other patients unless you have appropriate procedures in place to protect the spread of the virus in your hospital. That's what they said, okay? Radiation is not a virus. Radiation is, if I'm going to get cancer, and these people lost, they were radiologists, and they lost digits from the cancer in all of their hands and can no longer work. Radiation is not a virus. It is caused by the exposure to that ionizing radiation that's being emitted from the very tools that SMC is responsible for. And it's being emitted by all of those pieces of equipment for which they are obligated to monitor and make sure that their people aren't overexposed such that they receive cancer. They did not. Right? It's not patients, it's for the benefit of the workers at the hospital. And there is no question that these doctors were workers at the hospital where the ionizing radiation equipment was located. And so whether you look at it from the standpoint of employment relationship or you look at it from a substantive nexus, and you can decide the case on either basis. If you don't want to address the issue of employment, it's no different when you look at it from this substantive nexus, okay? There are really two essential elements that they talk. We got 7 in Ross, right, when it's a safety-related claim. But when you look at all of the lineage of cases afterwards, it really comes down to whether the action complained of is substantially related to the provision of health care for patients. That's what they say. Is it really related to that? And then the second thing that they really go off on, it's not even one of the 7 factors, it's the 8th factor, I would call it, and that's the need for expert testimony, right? Is an expert needed? Well, the answer here is yeah, an expert's needed, but not the expert that is called out specifically in the Healthcare Liability Act. In the Healthcare Liability Act, the expert for a claim against a healthcare provider, and I want to make sure I quote the language correctly, the claim against a healthcare provider has a second element, and that second element is, I got to find it, has knowledge of accepted standards of care for healthcare providers for the diagnosis, care, or treatment of the illness, injury, or condition involved in this claim. Okay? We are not making a claim at all about the diagnosis of their condition. I would say their own doctors, SMC's own doctors, are the ones that diagnosed them with cancer because of ionizing radiation exposure. Okay?
So what type
But
of expert would you normally use?
Would I use in this case? And this is exactly what I told the trial court. We would need 2 experts. And in fact, we've already reached out, but you'd have to have 2 experts, right? Probably 3. I'm not saying you don't need a doctor. You don't need a doctor to say this is skin cancer and it's basal cell skin cancer, and basal cell skin cancer can be caused by radiation. But to get to the liability aspect, we've got to show that they were overexposed because of Shannon Medical Center's failures, and that failure could be you didn't monitor them appropriately, right? You didn't check to see whether their radiation exposure exceeded the allowable limit for workers in Texas, and that's going to be in engineering, human factors. Those are the kinds of experts that you're going to need to be able to establish that liability. What should people working in and using radiation do to protect their employees? It may be a former OSHA person. The people that advertise in this arena, to answer your question, none of them are medical doctors. They're engineers who have designed and implemented, at the request of hospitals, ways to minimize exposure to workers from radiation. That's who's out there. You can Google it. That's who you find. Those are the people, and those are the people that we need to have. And not a medical doctor to prove liability, not a medical doctor to prove the liability relates to as an approximate cause of the injury, although we would probably have to have somebody in the medical community to talk about the effects of radiation on the skin, basal cell carcinoma, but not with respect to the liability and the other causation issues. Okay? So if you want to, and I'm going to be like my esteemed counsel, and I'm going to give back some time, but if you want to do, in here, what's really right, what makes the most sense, then you give full effect to what the Radiation Control Act and all other pieces of legislation that go with it, the administrative rules and regulations, you give effect to that. And you place upon hospitals and you place upon others in the industry the responsibility to follow those administrative rules and regulations to make sure that their workers are not exposed. And I can't emphasize enough that what we complained of in our argument under the scope specifically excludes, without any shadow of a doubt, it specifically includes measuring doses for purposes, measuring exposures to patients, because that's not what we're concerned about. We're concerned about that cumulative dose, not the one-time dose. Even though counsel, without any background or expertise, makes that suggestion. Well, the statute says otherwise. And in fact, many of the provisions in the administrative codes and administrative regulations apply only to workers, not patients, and not even the public at large. That's what we're complaining of, their inability or their failure to do those things to protect their workers in their work environment. And I stand prepared and ready to answer any questions that you may have, but I hope I've addressed the issues.
Thank you, Mr. Dreyer. Rebuttal?
I'll try to be brief, but that's not my historical nature. Let me start with, what did I write down as number one? X-ray, fluoroscopy, whatever it is, if you're overexposed to it, you're overexposed to it. So if it's leaking out to hit the doctor, it's leaking out to hit the patient, right? And so that's the problem with their argument is they focus on.
Here we don't actually know what the machine was, right?
And we don't need to because we know it's in the radiology department and the equipment that they're used to treat patients. It's not like in McNew, they didn't know what the source of the radiation was because they didn't even know that it was coming from the radiology department. Here we know because they've alleged they worked in the radiology department, and so we know it's X-rays and CTs and fluoroscopy is just a fancier X-ray that shoots in real time as opposed to shoots a one-time picture. So it's all the same technology and all the same equipment, and so we don't need to know that it's this particular machine because we know that's what's in the X-ray department or the radiology department that emits X-rays. It's CTs and not MRIs, CTs and X-rays and fluoroscopy, but it's all X-ray technology. The second thing I want to say here is when we get down about fairness and whatever, the last thing I think anybody could say is that the healthcare statute's fair to anybody, but that's not what the legislature envisioned when it wrote the statute because it wanted to help out healthcare providers, but that's their prerogative and has not been found to be unconstitutional just because it's some unfair line drawing that we're going to treat doctors who don't work from the hospital differently than the lab technicians who do work for the hospital. And there's an important distinction there because the lab technician falls into the exemption in the definition of a healthcare liability claim, and the doctor, who's not an employee of the hospital, doesn't fall into that exemption. And that's a line that the legislature drew after the Texas West Oaks case because it wanted to make sure that employees of the hospital that might have a workers' comp or non-subscriber case didn't fit that problem. The problem is the doctor just doesn't fit into that definition because the doctors don't work for the hospital, they work for Shannon Clinic.
Could you address the point he made about the type of expert you would need here? So what would an expert doctor?
Doesn't have to be a doctor.
Well, that's my question. I mean, what type of expert would you contend they had to have here?
So under 74351 R5, expert means, and then it has the various standards. And so with regard to a healthcare provider, it's somebody that knows accepted provisions of healthcare to testify about those things. And so if you have a machine in the radiology department leaking radiation, you get a director of radiology to say, hey, you needed to have it checked more often. Or you get the director of a hospital who talks to the people, like the engineering type people who they hire, and says, you should have hired somebody to come out and check your machines. So it's not hard to come up with somebody muckety-muck at the hospital, hospital administrator type, or the director of a radiology department to say what they're saying. It's very easily solved in that fashion, and it doesn't even necessarily have to be a doctor because you've sued a hospital, and that's a hospital standard, not a doctor standard. Now, admittedly, if they had sued, say, a doctor, that would be different. You'd need a doctor to criticize a doctor, but that's not what they did. And then real quick on the distinction between Limestone and the other case, Stevenson, I just know that Stevenson cites a case that quotes Limestone has the right to control the progress, details, and methods of the work. And so to me, that's why they're holding hands. And so I don't think that's a big deal. And then the other thing in Stevenson that I think is important is if you look at all the testimony in Stevenson, everybody said the garbage truck driver that worked for Waste Management controlled how the helper guy that day who was injured, controlled how he did his job. And what testimony do we have about how he did job? He says they control the machines, but that's the sleight of hand. We have to control the workers for them to be our employees, not the machines. And so while we may control machines, that doesn't mean that we're controlling the employee like we're supposed to, or the person to be our employee. And that's what he's mixing apples and oranges on control. One last thing, and I'll sit down to give you whatever time left I have, is I would just say, he says that they were paid on the work units based on their production at the hospital by the hospital, but that's not what the evidence shows. The only evidence shows that's Shannon Clinic, and there's no evidence of how they were paid in the affidavits. Sorry.
Thank you, counsel. Case will be submitted. Marshal will adjourn the court.
All rise. The 15th Court of Appeals now stands adjourned.
Do it again, brother.